my lords, would find at page number 20. The relevant portion being at page 21, my lords. The signature of the witnesses was not taken.
Whether this is earlier rejected or not, Lordship, that is no order has been annexed, Lordship.
But I have annexed the rejection order passed by the learned sessions judge at page 30.
No, whether you have approached this court before?
No, my lords.
Huh?
No. First application.
It will go to the appropriate.
The bail application was disposed of earlier.
Yes, my lords. On 11/3/26, before the honorable court, the judgment of my lords was
No,
placed.
I mean, the rejection order of this court is there in this petition.
No, my lord.
Why?
Because it is the first application before this honorable court.
No, this was Asmat Ali has been earlier disposed of in 21/1/2026.
21/1. Plus, I'm so sorry, my lords. I have not been instructed on that. I'll obtain instructions.
You'll have to bring on record. I mean, whatever the applications you have filed,
My lords.
you'll have to give all the facts, all details.
Of course, of course.
All
I
details.
bow down, my lord. Of course.
All details that you should take the instructions properly.
Of course, my lords. I'll file an additional affidavit.
On the
to that
prayer of on the prayer of Mr. A. Burwa, the learned counsel appearing for the petitioner, let the matter be listed after the ensuing vacation. In the
So-
meantime, you bring that, I mean, there will be holidays now, I
Of
mean,
course.
whenever you can.
Of course, sir. I'm so glad.
May it please your lordship, may be pleased to pass over the matter for the time being as Dr. Saraf.
Otherwise, my lord, this order, they have impugned, my lord, it will be operative till only 9th, my lord, till the date of election. They are apprehensive that it will continue till the declaration of results, my lord. It's a restraint order of, my lord, transportation in page 125A, my lord.
Just let him come then.
My-
Highly obliged, sir.
Pass on.
my lord. This is-
Non-APS for the petitioner when the matter was called for. Seeing the order dated to 6/6/2025, passed by coordinate bench of this court, as well as the order, as well as the office note dated 24/2/2026. It is seen from the office report that in spite of as seen from the office report that though a communication was made to petitioner numbers 1 to 123, the postal endorsement relating to only petitioner number 38 has been received, and no other postal endorsement. No, don't write like that. received, and postal endorsement as far as other petitioners are concerned, it shows in quotation in red, no such addressee, RTD to sender. One second. You write that as per the office note dated 24/2/2026, though a communication was sent to the petition numbers 1 to 123, no other and except for petitioner number 38, petition number 38, no communication, petition number 38, which has been received back with postal endorsement, no such addressee, RTD to sender quotation is received. No wakalatnama has also been filed. No phrase wakalatnama, no phrase wakalatnama or any communication has been received from the petitioners. Full stop. Then you write, it is seen that last several occasions, none appeared for the petitioners. In view of the aforesaid, this instant case is dismissed for non-prosecution. Order upon my side, madam sir. Office notes upon confusingly, sir.
Therefore,
Neatly, sir, kindly pass over for the time being, madam. LDB is in the lower, he is coming, madam.
Okay, pass over for time being.
Master.
takes
My lord, this matter relates to taking over a land of the petitioner by the APDCL without following the due process of law.
By APDCL.
APDCL, my lord.
Mhm.
Excellent. Well, I have some difficulty, but I could not properly prepare a case, madam. Otherwise, madam, we have filed affidavit, pleadings are ready. Yes, already
No, there
pleadings
was,
complete.
Earlier order was also there for the union to file an affidavit. That
You-
has also.
In our instruction, there is nothing that we didn't, it is, sorry, I didn't acquire, with madam, Union of India didn't acquire the land, my lord. So I have that instruction, my lord.
That's so you are saying that the Union of India is not involved.
Not involved, my lord. That is it.
No, my lord, what has happened actually, that Digaru Air Force Station was, that land was of. sort
Okay,
of-
there is some, then you file an affidavit, you bring on record, you bring on record.
With the affidavit.
You bring on record that you don't have any this thing. Okay, then we'll put it after the
After
vacation.
vacation.
After the vacation. Heard Mr. M. Khatane, the learned counsel for the petitioner. Also heard Mr. P. Goswami, the learned standing counsel for APDCL, learning for APDCL. And so A. Gayan, for A. Gayan, the learned CGC for Union of India, full stop. MS Gayan submits that she has received the instruction in the matter and would like to file an affidavit shortly. Full stop. Therefore, she prays for some time. Prayer is allowed. Let the matter be listed after the vacation.
on time to land.
Okay.
Date
Then
given.
first week of May, let the matter be listed in the first week of May. First week of May, APDCL has already, APDCL is already filed an affidavit in the instant matter. So in the month of May.
This is. My lord, around 14 acres of land has been taken for the purpose of school, my lord.
Purpose of?
School, my lord. Government has taken. And since 1977 till date, they have not paid the rent, my lord.
Have you filed an affidavit?
Yes, your lordship.
But last occasion, respondent education shall bring on record the stand by filing an affidavit. Here was
For
all.
respondent number 6.
Who is for the education department? Education department?
Reply to you with her.
And the government stand at 7, 9, 10, and 13, my lord.
Respondent number 6 is deputy commissioner.
Deputy Commissioner, my lord.
But it has been taken for respondent number 2.
Yes.
So respondent number 2 will be required. I mean, their
Yes.
stand will be required.
Yes, your lord.
The school is not functioning. It's jungle like all around, my lord.
They have just taken the land.
Just taken the land, 1977, no rent has been paid, my lord. Although there is a court's order, my lord, execution case has already been filed.
Mr. Goswami, Education Council, nobody is there?
Education.
Director secondary education.
Secondary.
Lordship may see.
No, I don't see any affidavit on record.
No affidavit filed, my lord. Lordship, the DC's government stand, lordship may find is para 7, my lord.
There are 7 of the affidavit.
Yes, 7 and 9. School is running in the said land for academic purpose since popularization till date as government rule. What is that academic purpose, my lord? There's nothing in the school, my lord. It's a jungle. They have in fact abandoned the school. There is a document, my lord, I can show, my lord.
So let them file an affidavit, Mr. Roy, otherwise it will be difficult.
Lord.
Without them, whether we can adjudicate the matter, no.
Lordship, I will.
But lordship,
Because last time they have,
lordship make it the last, my lord, last opportunity to them, my lord. Because this petition also filed on 2022, my lord. And my land has been taken, my lord.
heard Mr. J. Roy, the learned senior counsel, assisted by so-and-so for the petitioner. Also heard Mr. S.S. Roy, the learned counsel, appearing for respondent number 6,
5 and 6.
5 and 6. Yes, madam, what is happening in this?
Affidavit needed to be filed here, Your
No, why, I mean, the last time time was given. The respondent number, I mean, in 2012, from
Lordship,
2024. it's-
Monday matter may be posted, Your Lordship.
2024, we have taken time.
Your Honor,
From 2024 is going on.
It will be on Monday, like lordship.
Monday, how they will file an affidavit?
She's saying, my lord.
You can file an affidavit by Monday. You don't have any instruction, you don't have anything, then why you're saying that like, you will be able to file an affidavit?
Immediately after vacation, immediately after vacation.
And this is the last opportunity,
Yes,
otherwise your person has to come because you have acquired the land without giving anything to them. And you are not running a school also. Okay, the right, Mr. Roy Liflana, Mr. S.S. Roy for respondent 5 and 6, and P. Das for, MS P. Das for
I'm appearing for secondary education.
Secondary Education Department. MSP thus submits that she requires some time to file an affidavit in the instant case. It is seen that the last occasion, the council appearing for the secondary education has taken time to file an affidavit was on
Last.
22/7/2024. However, since then, however, in spite of a lapse of about 2 years, no affidavit has been filed till date. A last opportunity is given to the counsel appearing for the secondary education to file an affidavit in the incident matter. Let the matter be listed after the ensuing BU vacation.
Date, my lord.
After BU vacation,
Deeply.
let them file an affidavit.
I'll go and do it.
Obliged.
Obliged. Debate.
The GTL Infrastructure Limited, madam.
Hmm?
The GTL Infrastructure Limited, madam. Well, it took over, my lord, about, my lord, number of sites, my lord, of the, my lord, erstwhile ASL, madam. Now, my lord, there were pending dues bills, electricity bills against those, madam. And after taking over, my lord, they closed 117 sites in by 2000, my lord, November.
The
2020.
GTL infrastructure is what? What exactly they do?
It's a, my lord, the infrastructure company, my lord,
Hmm.
providing, my lord, maintaining telecom towers, madam.
Hmm.
Now, my lord,
Infrastructure company installing telecommunication.
Maintaining telecom towers and, my lord,
So maintaining
installing and maintaining both, my lord.
maintaining.
Yes, my lord.
Okay.
Basic infrastructure, telecom towers, my lord,
Hmm.
across, my lord, the country, including, my lord, the northeast region. Now, my lord, they took over, my lord, some sites of the Aircel, my lord.
ASL.
Aircel, my lord. Mostly of the Aircel, my lord, what had happened, my lord? Actually, my lord, there was a, my lord, merger, my lord. And, my lord, thereafter they took over, my lord.
Merger between ASL and
No,
this thing.
initially, my lord, the Chennai, my lord, initially, my lord, the Chennai network.
So, yeah, I mean, yeah. You all, I mean, this, your client was not involved earlier?
No, not involved. These
So,
are mostly
so
towers belong
these are the sites belong to
mostly
ASL.
the Aircel.
ASL. So, ASL got merged with somebody.
My ASL is no more there.
No more there.
They took over.
So you have taken over.
Yes.
You have taken over by way of what?
My lord, since my lord, there was a national NCLT order, my lord.
Hmm.
My lord, paragraph 5 I have described, my lord.
Hmm.
My lord, the GTL, my lord, was, my lord, that NCLT order was, my lord, to, my lord, that, my lord, the GTL will take over, my lord, the infrastructure business now owned by the CNI, the Chennai network, my lord.
So Chennai network is basically ASL or what?
No, Chennai network, my lord, all this, my lord, lordship, paragraph 5, my lord. I have referred, my lord. Single bench of the National Company of Tribunal, my lord. Under the scheme of amalgamation between Chennai Network Limited and the GIL, the GTL infrastructure, was pleased to pass an order dated 13th December 2017, stating the infrastructure business owned by CNIL are now acquired, owned by the GIL, that is the GTL, with effect from 25/12/2017. Pursuant to the said court order, all the cellular transmitting equipments and all or other passive infrastructure undertakings to CNIL to transfer to the applicant GIL with effect from 25/12/2017.
Correct.
Now, my lord, accordingly, my lord, they took this since ASL was also not there.
So it got affected from 25/12/2017.
7.
Correct.
My lord.
Then,
Then, my lord, they took over these towers,
Hmm.
and by November 2021, my lord, they closed 111 cases, my lord.
November?
2021. I'll give a list of dates, my lord. That'll be helpful. Very much.
No, I mean, but there were a lot of cases going on regarding non-payment of
Yes, my lord.
dues.
My lord,
So-
yes, my lord.
So some of the cases were closed.
Closed.
Correct.
So, my lord, November 2021, my lord, Annexure 4,
Hmm.
they wrote that we have closed, my lord, 111 sites.
No, you have closed those sites or like you have closed the cases?
Cases, my lord.
Huh?
Payment, yes, there was a non-redeeming sites, my lord. They're already closed, my lord. So we made the payments and closed those sites, my lord.
Mhm.
That's what happened.
Mm.
Now, my lord, then, my lord, we wrote a letter to them, my lord, saying that, my lord, we have closed 1,117 cases
Mm.
and about, my lord, 100 and, my lord, 673 cases remain, my lord. Non-radiating sites remain.
Those are still running.
No, my lord. These are all non-radiating, my lord.
613 sites.
No, 670, my lord, one, my lord, in fact. It was initially thought to be 600.
But anyway, some sites are there.
No, not there. Well, 671 sites, man.
Hmm. Anyway, some sites were closed and some sites were, I mean.
Yes.
Yes. Then,
Well, then, my lord, we say then we will not got hold of another, my lord, 423 sites bills, my lord. We, my lord, propose that we'll pay the money, but please give us such a waiver. The APTCL said, no, we are not committing anything. You deposit the entire money and thereafter we'll place the matter before the board. And if the board permits, we will give you that such a waiver. But that did not materialize. We paid the entire money and that's how it was. Those 423 sites are also not the issue here. That's will close. Thereafter, they remain, my lord, around, my lord, 17 sites, my lord. Sorry, 420 sites we paid, my lord, 248 sites remain now. 248.
so others, I mean, already closed.
Others closed.
So now 248.
Around 248 remain. Now, out of those 248, my lord, this is the issue starts with this, my lord. Out of this 248, my lord, we got, my lord, hold of bills, my lord, out of 187 sites. We could find out, my lord, bills. We wrote to them, but we had to, my lord, make a lot of effort to find out bills of 187 sites. Now, my lord, now the issue arises, my lord. Here, then, my lord, at this point of time, my lord, page 76, the APDCL introduced a searcher waiver scheme, my lord. Searcher waiver scheme. Page 76, my lord.
What does it call?
Searcher's waiver scheme, my lord.
Searcher
Waiver scheme.
waiver scheme. Okay.
My lord, Lordship inside page.
That is in
page
2023.
23, my lord. In anticipation of the approval from the board of director, and
Where it
page
is?
7,
Yes.
page 7, 22nd of January 2023, my lord. Annexure 10. In anticipation of the approval of the board of director, an opportunity is provided the consumers with areas to clear their dues with waiver of surcharge. Now, my lord, scheme A1, 100% waiver of surcharge. The entire amount of area surcharge will be waived on payment of 100% principal amount. This is very relevant, my lord, at one time within the period of the scheme. Now, my lord, we told them, my lord, that we have bills of around, my lord, 187 sites. And, my lord, we are willing to settle those. Accordingly, my lord,
Paying 100%.
paying 100%
100% principal amount.
principal amount. Exactly. And, my lord, we accordingly, my lord, paid this amount within that the time of the scheme. My lord, the scheme was. Sorry. My lord, I'm sorry, I'll be under, my lord, 78, the scheme, the provision is same, my lord, 100% principal amount, my lord, with the period of the scheme.
No, what?
My lord, space 78, scheme B, my lord.
Petitioner is in scheme B, your
Scheme
lordship,
B.
not in scheme A.
Yes, my sir.
Okay, scheme A and scheme B.
Scheme A is for domestic consumers.
Yes.
Okay.
And scheme B is for low tension and high tension consumers other than domestic consumers.
Yes, my lord, yes.
That is a page number 70.
Yes.
Okay, scheme A is not applicable.
Not a scheme B is applicable.
So scheme B is also same.
100% principal amount at one time period in the period of scheme. Lordship will see the period of scheme. 7/1/2023 to 25/1/2023.
So okay, scheme was valid for certain time. Okay.
Yes.
So it was about for 18 days.
For 18 days. Later on extent, I'll come to that later, my lord. But it was at that point, it was.
So he paid on 24/1/2023.
We before that, my lord. We informed, my lord, that on 23rd, we informed them that we have already paid, my lord.
Okay. So you paid for 187 sites.
187 sites.
Correct then?
Now, lordship, my lord, before that, my lord, I'll just place before lordship, my lord. We had prepared a chart, my lord. Page 92 onwards, my lord.
Page 92
Yes.
onwards.
My
Okay.
lord, these are the, my lord, chart of, my lord, the 187 sites, my lord. The figures of the 187 sites. Accordingly, my lord, from the, and my lord, this was drawn, this is extracted from, my lord, the bills, my lord, which I've also enclosed, my lord. That's why the petition is so big, my lord. Otherwise, page 98 onwards, my lord, and extra 17.1 onwards, these are the bills, my lord, we have in our custody, we had in our.
Page 92 onwards.
98 onwards.
98 onwards are the bill
Bills.
and like the amount that you have paid is shown in page from page 92.
Yes, my lord. So we accordingly, my lord, made this chart, my lord, in a tabular form, so as to, my lord, make it easier, my lord, and to calculate the dues. So we made this calculation, my lord.
Correct then?
Accordingly, my lord, we paid this money, my lord, and expecting that, my lord, the surcharge waiver will be given to us.
For 187 sites.
187 sites.
Correct.
We send them a mail on 24/1/2023 informing that the payments have been made, my lord.
Where is that?
My lord, mail is, that is, my lord, page number 91, my lord.
Yes, that I have seen, yes.
Yes,
Hmm.
we paid this amount, my lord.
So,
One, my lord.
so you have stated about praying, you have mentioned about,
These are the various payments made, my lord, amounts paid, my lord. So we paid 1 crore 24 lakhs and odd, 1
Yes.
crore 24 lakhs 6,000.
yes, yes, for 187 sites,
Yes,
correct,
for
correct.
187 sites, my lord,
mhm.
we have made the payment.
Right.
Now, my lord, accordingly, we send the mail, my lord. No, my lord, page 320 is the first order, my lord.
Yes.
This is by, they inform us, my lord. Please
Hmm.
find the attachment as discussed with you,
It was
I
done
for-
when?
320, my lord.
8th of February.
Yes, my lord, it is 8th of February 2023, my lord.
Hmm.
Please find the attachment. As discussed with you, I'm forwarding here with a list of 187 number NR sites. These are non-radiating sites, that is.
Non,
Non-radiating sites,
non what?
non-radiating,
Not radiating. okay.
non-radiating,
Hmm,
because these are all closed.
hmm.
After proper scrutiny of the principal and surcharge amounts against the same, in this regard, this is to inform you that a balance amount will be 74 lakhs 22,087.41 paisa is to be paid from your end against the remaining 75 number of sites subject to approval by the board of directors of APDCL.
75 means which 75 sites?
Well, we don't know that, Malad. That's where there's some confusion, Malad. How this entire case, Malad, is that how they got these figures and from where these, Malad, we said that you give us the bills. Our entire, Malad, case was always that you give us the bills, we'll make the payments.
Hmm.
But we only
So they have given you the bills of 187
we
sites.
could get hold of 187, 423 earlier,
Hmm.
plus 187.
So
So
423 gone.
Gone.
I mean, there is no dispute about that.
now only 187.
So now only 187. You
187.
said that 187, yes, 187 sites, you paid the money.
Yeah, we paid them.
Hmm.
Now they say 74 lakhs is pending. Then we wrote back, Malad, on next page, Malad, page 21.
Hmm. But you said like 248 sites were, I mean,
Remaining, yes, that.
remain.
Yes, Malad.
So out of 248 sites, you said that you could procure the bills for 187 sites.
187.
And as per the scheme, you have paid principal amounts for 187 sites.
187 sites.
And they wrote back saying that 74 sites,
75 sites they remain
75 sites are remaining.
remaining.
Are they talking about this 75 sites of, I mean, like 248 minus 187? Is it so?
Perhaps it should be 65. There must be a typographical error in that.
Okay.
Because it
But
should
they
not be
are
sev-
probably
It
mentioning
is,
about
it
that.
is mentioning about that.
Correct. Then,
It should not be 75, it should be 65.
so like they are saying that what 248 sites are running.
248 sites remain. There
yeah.
are some factual aspects I'll clarify later.
So 248 sites. So remaining from 248 sites to 187 they paid.
Yes.
So remaining 75 or 65, whatever.
It comes to 65 according to us because the original sites, number of sites was 620, 423 plus 250.
So they APDCL must have mentioned about the remaining sites. Remaining sites you have not paid.
Remaining sites which have not been paid.
Paid. Okay, correct then.
Therefore, Malad, our entire lot case was that
Hmm.
you provide us the bills against all those.
Hmm.
We are going to pay whatever is left, we are going to pay. But then we were in hold of only 187 sites payments we made accordingly.
Hmm.
Now, Malad, this letter came. Then, Malad, they issued another letter. Lordship will find, Malad, at page 21, Malad. Annexure 21, Malad, page 324.
Yes.
Now, in response to your letter dated 7/4/2020 reference, I would like to inform that the APDCL allowed the surcharge waiver by office memorandum so. As for the terms and conditions of the scheme, all the PDC, TDC consumers from both LT and HT categories are covered under B scheme, which allowed for waiver of the entire amount of area such as on payment of 100% principal amount at one time within the period of the scheme. However, it is seen that you have deducted both the area and the current surcharge on calculation of the reconciliation amount of rupees 1,24,05,685.58 against 187 PDF sites from your end. Also, discrepancy is found between reconciliation of the amount paid at your end, the payable reconciled amount calculated from our end. Hence, your application could not be processed under surcharge waiver scheme dated so-and-so. On further submission of your application for surcharge waiver through BOD APDCL, the plea got rejected, which has been intimated to you by this office letter dated 25/3/2023. As such, you are requested to do the needful for depositing the remaining amount of 1,71,753 so-and-so to avoid further accumulation of surcharge and for final closure of the accounts of PDC. Now, this amount now from 75 lakhs and odd to it has come up to another 1,71 lakhs. In this letter, my lord.
But they have disputed certain things here, right?
I'll come to that, madam.
Hmm,
First dispute they have raised with regard to, my lord, the so-called current surcharge.
hmm. So they are supposed to, I mean, while paying that amount, they are waiving only your
Surcharge.
surcharge,
Area
area surcharge,
surcharge.
area surcharge,
Yes,
not current surcharge.
I'll come to that, my lord. That's why it's relevant, my lord.
Hmm,
Now, these are, my lord, non-radiating sites, my lord, which are already closed.
Hmm.
And lordship will see the bills. These bills are not, my lord, current bills, they're all pending bills.
hmm.
So therefore, my lord, area surcharge, and my lord, the scheme says, first of all, the scheme says 100% principal amount.
Hmm.
It doesn't say principal plus current surcharge.
Hmm.
Now, what has happened here, my lord? In these particular cases, lordship will, if I have all the, since I've annexed the bills also, your lordship will find that the bills are old bills, my lord. For example, lordship takes a
Bills that you have submitted from page 98.
98, my lord.
Hmm.
Lordship will just take up one bill, my lord, just for reference, my lord.
Hmm.
Lordship will see the bill date.
Yes.
11/2/2020.
Hmm.
So, my lord, these are not current bills. So therefore, the entire amount, my lord, as we calculate, my lord, it will fall under the category of area surcharge.
But it won't be current bills only because you need to pay whatever was consumed earlier.
Yes, so there is no question of current bill at all.
Hmm.
So therefore, these are all areas which have accumulated over the years. And all this, my lord, though the bill may say, my lord, it's a current surcharge, but this amount as of now, or when we paid, my lord, it had come into the category of, my lord, area. Area means what? Something which is pending of the earlier period. So therefore, my lord, though these bills may have referred to some of this, for example, my lord, some amount as surcharge, my lord, carry, my lord, current surcharge, but the, my lord, for example, here, my lord, in this particular bill, there was no current surcharge. Page 98.
Now tell me one thing, and let me be very clear about this. In 248 sites, these are non-radiating.
Non-radiating.
Those are closed.
Closed, dead sites.
Those are closed, so no electricity is supplied to those.
No.
No,
So there is no consumption.
non-radiating sites means they are not radiating the telecom signal. Nothing to do with the electricity, your lordship.
For electricity, they may be
Electricity,
consuming.
there is a difference. There is
They,
a
they,
temporary
they may be consuming the electricity. That's what
there
you're
is a
saying.
temporary disconnection and a permanent disconnection.
Hmm.
Permanent disconnection had not been done in these sites. They
Hmm.
were consuming electricity.
So some consumption is there,
Some
maybe
consumption
there.
is there and
Okay.
surcharge is levied.
If it is there, my lord,
Hmm.
that's why we are saying, my lord. If it is there, give us the bills.
Hmm.
So how do we pay electricity bills, my lord? According as per the bills raised, my lord. Now here, so therefore we said, my lord, whatever was there, it actually falls in the category of current surcharge. And your scheme says you have to pay the 100% principal amount. We paid this 100% principal amount accordingly.
Hmm.
Whatever the calculation was,
Hmm.
we have paid this 100% principal amount as per their bills. Our basic case is that this is our payment, 1,24,00,000 and odd. This is as per the 187 bills we have, and we have paid it.
Hmm.
They say, no, you have some more dues. Now the question is, if I've got some more dues, where are the bills? I say I don't have the bills, and in fact, I can show from the mails that we had requested the bills earlier also, but these bills were not provided by them. So unless these bills are provided, we cannot pay them. Now in their stand in their affidavit also, They are merely saying that you have so much of dues to pay. In this, in the letters, in the impugn orders, as well as the affidavit, they say you have so much of bills to pay.
Now, what is the stand on non-providing the bills to you?
That also they're not very clear. They say that we file a detailed affidavit if necessary. That's what they have taken the stand. But these are the dues you have to pay. Well,
No,
And
no, the providing of the bills, I mean, if there is some areas
Mine.
and there are some areas, I mean, like the amount is huge. And how to procure the bills? I mean, they're supposed to give it to you or you need to approach them, what?
Malad, we have been approaching their offices, Malad, because these are scattered over all over the state. We have been approaching their offices. We have tried to, and whatever we have gathered, Malad, on our own volition, we have gathered, Malad. Malad, that's why, Malad, we said that give us the bills, we'll make the payment. Now, therefore, now in the affidavit, they say, Malad, there is a total outstanding of 2 crore 95 lakhs and odd. Page 335, Malad.
Page 3,
35, Malad.
35,
Yes, Malad.
yes.
They, well, of course, they have now added both the current and surcharge also and area surcharge also, because according to them, the scheme has not been accepted. So our case has not been accepted for the scheme. So therefore now they are claiming the entire dues. 2 crore 95 lakhs and not, page 335, Madam. Para
Yes.
9.
Hmm.
Now in para 8, my lord, there is another dispute, of course, which is not there in the, my lord, but in para 8, they say, we did not, my lord, while my lord calculating these 187 bills, we did not take into consideration the adjustment amount column in each of the energy bills prepared. Now, my lord, our case is that this entire dues which you have calculated in the form of the chart, my lord, takes into account everything. Adjustment is something, amount is something which has already been adjusted, which is being, after which they have raised the final bill, my lord.
What is the adjustment column amount?
There is, my lord, in the bills, there is a adjustment column, my lord.
Hmm.
In some cases, these are reflected, some cases not, these are not reflected.
But this adjustment is done for with the prior bills or what? I mean,
My lord, Lordship will see page 103, my lord.
103.
This is one bill. Billing details, my lord. Billing details, current demand, page 103. Billing demand, billing details, sorry.
Billing details, yes.
Yes, current demand,
Current demand,
9,000 something.
outstanding amount,
adjustment amount,
Hmm.
government subsidy, solar rebate, net bill amount.
So adjustment amount is basically they have deducted.
They deducted. So it's part of the net bill amount. Now, Lordship will see the chart that we have prepared, my lord. Serial number 6, my lord, is that particular bill, my lord, which I'm referring to.
Serial number 6,
Serial number 6, it should be, my lord. Just let's verify.
not serial number 6.
So, serial number 6, yes. Yes, ma'am. Serial number 6, ma'am.
Hmm?
Serial
Serial number
page,
6.
Page 92, madam. So, my lord, the total outstanding we have taken into account 70,592. That is the amount payable on due date as per that bill, my lord. And after deducting, my lord, the surcharge amount, we have paid this amount of 31,916 and again.
No, the total outstanding dues was 70,000.
70,590.
So you paid 31,000.
Yes, well, after deducting the surcharge. So that calculation will come out.
Okay.
So we accordingly, Miller, paid this amount. So therefore, their contention that we did not pay the adjustment amount, did not calculate it, is not correct. We took into account whatever the bills they were raised or with us, and we made the entire payment as per that will be done. Now, their stand is, my lord, that it is not reconciling against our, my lord, figures or dues. The question is, my lord, I ask myself this, my lord, how do I, my lord, reconcile? What do I reconcile against? They're simply saying that our figures and your figures are not reconciling. We say we have paid the bills as per the bills raised by you, which are available with us. If you are saying that something else is payable to you, please give us the bills, please show us the bills. They're not doing that. They're simply insisting, no, this amount is due, you paid to us, and it is not reconciling with our figures. The reconciliation has to be done against certain parameter, certain figures, certain bills.
Is there any forum to, decide all these things?
For billing issues, there is an alternative remedy. There is a
Mhm.
consumer grievance redressal forum established by the Assam Electricity Regulatory Commission.
Mm.
It has an appellate body also before the ombudsman.
Mm.
But if on the issue of waiver of the applicability of the waiver scheme, perhaps I may be able to satisfy your lordship on this. But regarding specific
No,
amounts.
see, waiver scheme, they're not challenging the waiver or like anything about the waiver. They are only asking about reconciliation. Correct.
Yes.
You are saying a different amount, they are saying a different amount.
Different.
Whether this issue can be decided by alternate remedy or alternate forum or not.
Well, just make a small submission here, madam. What has happened in our case, madam, this has been, well, whatever we've been rejected.
See, these are very technical
Technical.
issues. Technical issues, how they calculate it, how they adjust it, how surcharge is calculated. These are something like which only technical and specialist people can do it. And for that, if a specialist forum is there, I'm just deliberating whether
understand.
there is a forum, because
Exactly.
otherwise this cannot be decided just like that.
Exactly.
May I just make
First of all, madam, there are two issues basically. One, whether we fulfill the surcharge.
No, you are saying is that you have procured the bills
Yes.
for 187 sites, and as per the bills, you have paid the money.
Yes.
Now they wrote you back saying that for this 70 lakhs rupees is still due. That was the first letter they have written. Then you have replied back. Then they have come up with another letter to you saying that like there was some mismatch about the payment, which they may have calculated later on or whatever. There are certain amounts like adjustment amount and all which has not been taken into account.
Yes.
So because of that, your bill has gone up to something around 2 crores.
Yeah.
No, 2 crores, right? Something about 2 crores. Now, thing is that you're saying no. Whatever the bill that you have given me, I have paid, and I have paid. You have made a chart also showing that like those amounts have been taken into account. Now they are saying no. There are some differences. Now in that situation, because this calculation of electricity bills such as areas is a specialized domain, right? So whether there is an alternative remedy or not, and another thing is that if there is an alternative remedy, a forum, if there is an alternate forum, then whether you should have gone there or not, that is one thing. And secondly, if you say that no, if they're going there also, I will not get relief. That is why that I have come to this
Yes.
court. That is your issue, right?
Yes.
And is there any other issues?
No.
Hmm?
That's not coming.
Hmm.
So far as my lord, going to other forum is concerned, this amount as per the scheme, my lord, expecting that the surcharge will be waived. And since the scheme is there, it's not their case that we are not entitled to be in the scheme.
Hmm.
They admit that we are in the scheme B. So therefore, there is no quarrel on that. So therefore, whether this scheme which has been implemented, we can be left out of the scheme in a discriminatory manner. That's the first question. Now, my lord, the other part is that our entire claim has been doubled, let's say, or has multiplied because of the permitting or non-allowing us to have the benefit of the such a scheme.
The SARSA scheme, they have given you benefit. You have
No.
already paid to one crore
No,
20
they have-
lakhs.
Because they have rejected. Now they are.
Now they have rejected. Now
Yes.
rejecting, they are saying that you'll have to pay 2 crores of rupees.
Now this. Mechanism which is there, it starts from the lowest, from the assistant general manager post. Now the board of the APDCL has itself looked into the matter and then said that you do not come under the surcharge waiver scheme. Now, whether going to these forums.
No, what was the reason they have given?
The interim orders, lordship, just go through. Page number, my lord. 321 is one, my lord, then 324 another. I'll read all of them, my lord. Page 321, my lord, an extra 19, my lord.
321 and 324, yes.
321, 324, and 327, my lord. First, my lord, they say 75 lakhs, my lord, is due, page 18, my lord, annexure 18, 320. Then, my lord, 321. 25.
The
three-
T21, is this a rejection?
Yes, my lord, this is a rejection. Kindly refer to the letter under reference, wherein it was informed to you that the amount of rupees 1 crore 24 lakhs and odd deposited by a company against 187 numbers of PDC sites on 24/1/23 in the APDCL corporate principal account will be finalized and adjusted after taking approval from the higher authority of the APDCL. Accordingly, the matter was placed with the board of directors of the APDCL for waiver of the surcharge amounting to rupees 96 lakhs and odd against 187 numbers of non-radiating sites after proper reconciliation and finalization of PDC amounting to rupees 2. So, however, the board of directors did not agree to the above proposal and rejected the request for surcharge of waiver against the said 187.9 sites of PDC. I therefore request you to do the needful for depositing remaining amount of 1 crore 71 lakhs and odd, so and so for final closure of the accounts against the PDC sites.
So 120, 124, 1.24 they have already taken.
They have taken.
Now they are saying that like 171 is required to be paid.
Because
So you will not fall under a waiver scheme.
that's what they're saying, but there is no reason given. It says that didn't agree with the proposal. That much only.
Hmm.
No, nothing speaking about that. Then page 324.
Yes.
In response to a letter dated 4/7/23 under reference, I would like to inform you that the APDCL allowed for surcharge waiver by office member number so-and-so. As per the terms and conditions of the scheme, all the PDC and TDC consumers for LT and HT categories were covered under scheme B, which allowed for waiver of the entire amount of surcharge for payment of 100% principal amount at one payment. So 100% principal amount is the main criteria at one time within a period of the scheme. However, it is seen that you have deducted both the area and the current surcharge on calculation of the reconciliation amount of 1 crore 24 lakhs against 187 PDS sites from your end. Also, discrepancy is found between reconciliation amount paid from your end and the payable reconciled amount calculated from our end. We do not know what is their material on the basis which they have reconciled. This is one of the basic plank. We have paid as per the bills we have raised. You say you have got reconciled with some other figures. What is those bills or what are those figures? How do you know that?
Their stand is only what? The affidavit they have.
Affidavit also very vague, my lord. They do not say against what they have reconciled.
Mr. Pathak, I mean, your affidavit seems to be.
Paragraph numbers 9 and 10 are, it clarifies your lordship.
9 and 10 I have gone through, but 9 and 10 doesn't say explain anything.
My lord, if my learned friend, after my learned friend,
Then
gives
you-
submissions, I'll just clarify.
Ah,
that.
sure.
So, my lord, then they say, hence your application could not be proceeded under such a waiver
Hmm.
scheme of so-and-so.
Hmm.
Our further submission of your application for such a waiver through BOD APDCL,
Hmm.
the plea got rejected, which has been intimated to you by letter dated 25/3/2023. As such, you are requested to pay the needful by depositing the remaining amount of 1 crore 71 lakhs and odd to avoid further accumulation of surcharge and final closure of the accounts against the PDC sites. Then, my lord, we again write to them, represent before them, and then page 20, my lord, 327. Page 327, annexure
So
23.
what is your letter? You just read your letter.
My letter, my lord.
Yeah, 325.
325, Miller.
Hmm.
With reference subjects and the reference subject and reference cited above, we'd like to reiterate the contents of a letter at reference number 2 and further state that but various communications are mail dated so-and-so, 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 requesting you to confirm the payment of 187 sites and provide accounts details so as to enable them to make the payment within the stipulated time period under such a waiver scheme. By your email dated so-and-so, you had mentioned that we are free to deposit the amount assessed by us, designated an account mentioned within the stipulated time. You also mentioned that the amounts submitted by us are subject to final reconciliation.
Mm.
Accordingly, by the email dated so-and-so, we had informed you that we had made payments towards 187 sites under the such a waiver scheme and requested you to close the said accounts as per PDC and issue PDC certificates. From your above mail dated 23rd January 2023, 20th January, it is evident that you were aware of the payments of 187 sites under the surcharge waiver schemes, and that is why you provided us account details. In such circumstances, the payment of the entire amount under the such a waiver scheme, you cannot deny the same at this juncture as the same were paid as per the scheme B1 issued by your office of the APDCL. in view of the facts, we would like to again request to reconsider the amounts of the said payments.
No, your writing is only simply you are saying that you take my bill, you take my money.
Yes,
But there is no explanation. I mean, you have not sought for any other information.
because the
You,
bills.
no, you have, I mean, show me from any of the letters that you have written about like how it does, how your
Yes.
amount has become this much. We do not have any knowledge about this. Have you written to them?
Well.
You show me from your letters.
Yes, well, page 328.
Page 328.
Next letter, madam.
Hmm.
With reference to the subject cited herein,
Hmm.
above regarding rejection of our application for search and waiver
Hmm.
of 187 sites and consequent demand for payment of an outstanding amount of so and so.
Hmm.
We'd like to state that we have not been given a proper, just and reasonable explanation as to why our application for such a waiver of 187 has been rejected. And also as to what criteria for availing such a waiver has not been fulfilled by us. Further, nothing has been indicated as to how the amount now claimed has been arrived at. In view of the above, we would like to request you to kindly provide an opportunity of hearing in person at the earliest, along with the all records documents available with us, so that the same pending case can be resolved amicably across the table once for all and for all. Looking forward for an early reply and response from your end. Now,
This
then-
was not replied to by them.
This was not replied to, therefore we approach this.
So this was the last letter
This
you have
was the
written.
last letter.
But prior to that, you have not written anything about
Prior to
this.
that, my lord, because this correspondence at that point of time, since we had made the payment, my lord, we did not write in that way, my lord. But once it was finally rejected, my lord, then we, my lord, wrote that how you have calculated the dues, just tell us, my lord.
No, this, I mean, earlier letters were not sufficient. I mean, maybe
Earlier
this
letters
letter
were-
you have, yeah, this letter only you have sought for,
My lord, my lord.
sought
Earlier
for certain
letters
information.
were-
But earlier letters, you have only saying that like,
Yeah.
I have paid this amount and you should reconsider and take the amount.
True, my lord.
You haven't taken
Because
it,
that,
yes.
because, my lord, they were hopeful, my lord, this matter will be resolved, my lord. Therefore, this was not, my lord, now what has happened, my lord, therefore, my lord, our basic contention is, my lord, that so far as the searcher's waiver scheme is concerned, my lord, that a decision has been taken by the board. Now, if you go to the lower level authorities, my lord, they will not be able to overturn that. So that will not be an efficacious remedy, first of all. So therefore, my lord, we approach this honorable court. That, since these billing disputes, my lord, are, my lord, looked up by general manager and assistant general manager, my lord, people, my lord, at the beginning. Then, my lord, it goes up, my lord, from step by step. These are in a mode of appellate forums, my lord. So the first thing is, my lord, that since the board has already decided is that we are not entitled to such a waiver scheme. And my lord, now they're claiming dues against. the searcher's waiver.
Whether this issue can be brought under the purview of the authorities or not, that has to be seen. I mean, whether it's a board or it's a like governor, whoever. But like if there is a statutory forum,
My lord.
then you can of course go there.
The
That
difficulty
doesn't
is,
make
my lord,
any,
that once, my lord, the highest authority of the department.
that doesn't
has decided,
matter, that
how can,
doesn't
my lord,
matter.
lower authority, my lord, exercise the
See,
jurisdiction?
that's a statutory forum.
True, my lord.
State-
Even if it's there, my lord, but then since they're all, my lord, dependent on, my lord, they're all, my lord, subordinates to, my lord, those authorities, my lord. The assistant general manager, my lord, can he, my lord, assert, my lord, what the board has decided, my lord? He cannot, my lord. My humble submission, my lord. Even he may be a statutory authority, but he's under that wing of that organization, my lord. He is not an independent authority as such.
But it'll go up.
My lord, that's the first stage we have to go, my lord. So, and that too, my lord, these are bills scattered over all of the state, my lord. So each and every bill has to be, my lord, looked into by different, my lord, bodies, my lord, in different parts of the, my lord, state, my lord. That's another part of the story. But then, my lord, basic is that, my lord, these are all, my lord, within the organization. These authorities, the scheme which is there, my lord, it's within the authority, within the, my lord, the hierarchy of the, my lord, office. So once the board, the final authority of the APDCL has decided, can the junior level officers, my lord, sub what the board has said? It's, my lord, practically, my lord, impossible, my lord. So therefore, my lord, that is one aspect of the matter.
Then I mean, it will be, there will be no point of, I mean, having these statutory bodies.
No, it would have been what, my lord, had it been, my lord, a different issue.
No, I understand that what you're saying. I mean,
because-
like a general consumer probably would have,
Yes.
that is what you're saying.
Initial stage, had this searcher's waiver, because whether the searcher's waiver scheme benefit we are entitled, not the APDCL board has decided. The lower authorities which cannot decide that.
Okay, let us hear him, then we'll hear you again. I mean, you will get an opportunity.
Ma'am.
Because I mean, I understood your case, what
Ma'am.
you're saying.
If I may take your lordship to the prayers first made in the petition. The prayers, your lordship will find that page number 32 of the petition. So basically, he is challenging an email dated 8/2/2023, which my learned friend has already taken your lordship through. The communication dated 25/3/2023, the communication of the rejection, and the subsequent communication dated 27/4/2023.
Yes.
And then he wants a mandamus, the prayer number 5, directing the respondent corporation to accept the payment made by the petitioner with regard to 187 sites in terms of the surcharge waiver scheme as per the payments made, and close the 187 accounts by issuing the PDC, permanent disconnection certificate, stroke no dues certificate. So basically, the scope of the dispute before your lordship, in my understanding from the prayers made, is whether the surcharge waiver scheme applies to them and whether the rejection has been correctly made. If I may take your lordship to the scheme now for once, which starts at page number 76. This is the scheme whose
Yes.
benefit they are praying for before your lordship.
So A is not.
A is not applicable to them.
B is
I'll just
applicable to them.
show one line at the beginning of the top
Yes,
of page
yes,
number
yes,
76. It says in anticipation of approval from the board of directors. So the approval of the board of directors is sine qua non for application of this scheme. Now they are concerned with scheme B, your lordship, which starts at page number 78. Scheme B, applicability for all permanent disconnection stroke temporary disconnection consumers as on 31/12/2022 from both low tension and high tension categories except domestic A. So they are claiming the benefit of scheme B1, your lordship, because they are saying that they have paid 100% of the amount. Now to claim the benefit of scheme B1, the requirement is the entire amount, lordship will kindly take a note of this, the entire amount of area surcharge will be waived on payment of 100% of the principal amount at one time within the period of the scheme. So what will be waived of your lordship is the area surcharge.
Area charge are till the date of payment?
Areas, why I emphasized on this term area surcharge is because tariff, electricity tariff changes from year to year. So every year the percentage of surcharge is fixed. It may be changed or may be kept same by the ARC. Depending upon that, surcharges are classified into area surcharges, which are for the previous years, and the current surcharge, which is at the rate of tariff fixed for that year, your lordship. So there are two different categories of surcharges. The bills will make it evident. So this scheme was only for waiver of the area surcharge, and for getting that benefit, the rest of the entire amount had to be paid by them, the principal amount. And this amount had to be paid, your lordship, before 25/1/2023.
That they have paid.
According to them.
According to them.
According to them. So the dispute, your lordship, before your lordship is only regarding the 187 sites. So that
So other sites are not relevant.
not
for this
before your
case.
lordship now, because that communication which was addressed, that email on 8/2/2023, that is regarding the 65 other sites, which is perhaps not before your lordship now. That is not, it does not cover the 187 sites, your lordship.
Now
This is the subject matter of the
issue is
dispute.
only with the 187. side.
187.
So whatever is remaining, that is not.
That is not before your lordship.
Correct, correct.
So,
But at that time, when you received the bill,
my lord,
the communication that you have sent,
My
that
lord.
something is pending,
my lord.
that was, not relevant for this case because, that is not required.
The
I mean,
first communication of 8 to
first
2023,
communication.
that is perhaps not relevant, in
not
my humble
relevant,
understanding.
yes.
That is regarding the other remaining
Mhm.
sites.
Then, only intimation was given that you have received this much of money, but for remaining, you have not
65
paid.
sites, this is pending.
Correct, correct.
The first communication,
Mm,
yes. My lord, so regarding those 187 sites,
Mm.
they say, if I may take your lordship
Mm.
to an email
Mm.
at page number 88.
88.
88. This is an email addressed from them to APDCL on the 19th of January 2023.
19th of January.
Yes.
Is prior to the payment?
Prior to.
Prior
They
to
are
the
now
payment.
within the time period. 25/1 was the cutoff date. 19th of January, they write, Dear sir, as discussed today at your office, we are eagerly waiting for confirmation and bank account details. As per your requirement, we already have handed over a file with all 187 non-radiating bill copies to your office yesterday. Also, the soft copies have been sent to you through mail. So please expedite. We also need some time for our payment process. We are desperate to pay and settle these issues within 25th January with surcharge waiver. So the payment is, they are saying that kindly
Settle the issues, okay.
settle the issues.
Hmm.
In response to that, your lordship,
Hmm.
our response is on 20th of January at page number 89.
Page number
89, the next page.
89, yes.
Dear sir, with reference to your request in regard to confirmation and details of bank account, please be intimated on the following. The amounts submitted by you from your end are subject to reconciliation as insisted upon by them. You are free to deposit the amount assessed by you to the designated account mentioned by you within the stipulated timeline. In the event of any difference in adjustment on final settlement, the same will be adjusted in descending order of outstanding amount. Now, what they do on page number 90, they're still within the time frame now.
But still
On
within the
page
time
number
frame.
90, on the 23rd of January, they write back to us.
Yes.
Please refer to the mail dated 20th of January 2023. Thanks a lot for your cooperation. We are processing the full and final payment against 187 non-radiating sites at so-and-so with the ongoing surcharge waiver scheme dated so-and-so. The payment will be done on or before 25th of January 2023 and the amount is rupees 1.24 crore. The total amount as per your bills, reconciled PDC stroke final bills collected from your subdivisions against the 187 sites is rupees 2.34 crore, out of which the surcharge portion is 110 crore. So, Lordship, the stand taken now that they did not have the bills, your Lordship, perhaps that is not tenable because they had the bills, they had collected the bills, and according to the bills collected by them.
No, they are saying that they have collected the bills.
Yes. So the figures that we have arrived at, your Lordship, I'll just now they on 24th.
So you are saying that whatever the bills they have collected,
in,
from there only they can, I mean, the amount comes to this much.
yes, and they have not paid the amounts which was due from those bills itself. There were no separate bills.
Okay.
So on page number 91, your Lordship, on 24th of January, they write to us saying that in continuation of your previous email, an amount of rupees 1 crore 24 lakh 6,616 rupees
So this is
has
paid.
been paid. And to substantiate that, at page number 92, your Lordship, they have enclosed some tables. Now, I'll just show your Lordship two bills because there lots of bills are there. Two bills I'll just take as a sample study. I'll just show your Lordship. Bill number 1. The number of the bill is 400,471,186845.
Yeah.
According to their own calculation, the principal amount is rupees 925.
Yes.
There is no area surcharge. There is no current surcharge. Total outstanding dues are 929. Perhaps some cess has been some cesses are also there. They have paid 925 only. They have not paid the entire amount here also. 3 rupees is still left. 4 rupees. Now at number 6, another bill. 900,733,104. The principal amount is 31,968.57 paisa. The area surcharge is 37,240.7. And the current surcharge is 1,383.36. So they know there are two different components. Area surcharge and current surcharge are two different components. They have paid 31,969. What is now sought to be projected before your Lordship is that both the surcharges are the same. I'll take your Lordship to the bills. Both the bills are enclosed.
Only thing is that in the scheme,
The scheme.
scheme says the area surcharge.
Only area surcharge.
Yes. So
You have to pay the current surcharge. Only the waiver is of the
is for
area
all
surcharge.
cases.
The current surcharge has to be paid. So
So they have not paid that.
they have not paid. By their own admission, they have not paid it.
In spite of knowing that
In spite of knowing
there
that-
is some current charges
Yes.
pending.
If it was a simple domestic consumer, your Lordship, that can be expected. This is it requires technical know-how. But from a qualified, big, I'm sure it's a huge company. Having technical expertise, not knowing that the area surcharge and the current surcharge are two different components, and the bills reflect it, your Lordship. It does not require much technical knowledge also. If I may take your Lordship to these two bills, which I had just taken your Lordship through.
The same with the other bills also.
Same with other bills also.
Ultimately, the admitted fact is that they have not paid the current charges.
Yes.
They have deducted it from their bill.
They have deducted it.
They paid only the
They
area
have
charges.
paid an amount which
And your case is that because the current charges is not paid, That
Therefore, you
amount
don't
cannot
get
be,
the
amount
benefit of
cannot
it.
be taken, and
Yes.
that amount cannot be waived, and that's why you have rejected there.
Because the law is
Mm.
for getting the benefits of a fiscal waiver scheme, for an exemption scheme such as this,
Mm.
it has to be strictly construed to get the eligibility under the scheme.
Mm.
So once you fail to meet the eligibility criteria,
Mm.
then you cannot claim any benefit. So
Mm.
the entire amount that is payable by you has to be
Mm.
recovered.
Mhm.
So if I may take your lordship to the first bill which I had shown,
Mhm.
that is bill number 40047186845.
Correct.
That is at page number
98.
98.
Yes,
Now your lordship will kindly see
Mhm.
at the bottom of the page, there is a breakup of the charges.
yes.
There is a box.
Mm.
Outstanding surcharge and current surcharge are both zero. As I had shown your lordship in the first bill. In this bill, there is no outstanding surcharge and current surcharge, but they are two different components. Both are zero.
Outstanding and this thing is, yes,
Both are
zero, correct.
Now the second bill which I had shown your lordship.
Bill number 6.
Yes, that is at page number 103.
Huh.
That is bill number 900733104.
Yes.
Lordship will kindly have that table at the bottom of the page.
Mm.
There your lordship will see arrear surcharge and current surcharge are two different components
Mm.
having different amounts. One is 37,247 paisa and one is 1,363. So the scheme was for waiver of the arrear surcharge, but the current surcharge they have to pay. Now, if your lordship comes back to the table which they have themselves enclosed
Mm.
at page number 92, serial
Mm.
number 1 and 6,
Mm.
they have only paid the principal amounts. The current surcharge they have not paid. Now, so the rejection, your lordship, is basically on two grounds. Firstly, you have not paid the amounts that were required to be paid under the scheme. And secondly, the scheme itself says that it is subject to the approval of the board of directors. In your case, the board of directors has rejected. And therefore, you cannot give you the benefit of the scheme.
So their only case is that, I mean, as per the scheme, there is no specific statement about the current charges.
Current surcharge.
They only say the area sources. The area sources means current sources. But
Yes,
area sources includes current sources. That is
Yes.
their, that is their.
That is their case. But the scheme itself says specifically that it is for waiver of the area surcharge. It does not have anything to do with the current surcharge. That will be the balance amount which is payable by them. And only upon payable of their entire 100% of their balance amount as per the scheme are they eligible to get the benefit.
Mhm.
Now, if your lordship has,
So you take me to your affidavit.
yes, if I may take your lordship to paragraph numbers 9 and 10.
Yes.
That even though the proposal for surcharge waiver of 187 PDC sites of the petitioner were considered for being placed before the board of directors of the APDCL, considering the request of the petitioner for an amicable settlement of the long-standing pending issue. On reconciliation of the assessment made by APDCL of the 187 PDC sites, it was found that the total outstanding amounts stood at principal outstanding rupees 1,98,27,772.99 paisa. Surcharge amount, current surcharge plus area surcharge, rupees 96,85,065.87. The total outstanding amount, rupees 2,95,12,838 from 96.86 paisa. That the deponent states that the aforesaid outstanding.
This chart could have been made in a better way, I think.
Yeah, I believe.
It could have been
yes.
separated, no? These two
This
things.
could have been separated.
Hmm?
I bow down, your lordship. This could have been separated.
Hmm.
These issues are not very well clarified.
Hmm.
So if I may,
Yeah, para 10.
para 10, that the deponent states that the aforesaid outstanding amount exceeds the principal amount of rupees so-and-so deposit by the petitioner as per its own assessment on so-and-so. By email dated 8/2/2020, the petitioner was duly informed and called upon to deposit the said balance amount before the meeting of the board of directors. In fact, upon the request of the petitioner, so on and so forth, your lordship. So,
Yes.
if I may take your lordship
Hmm.
to the rejection order at page number 321, your lordship.
Yes.
Because kindly refer to the letter under reference wherein it was informed to you that the amount of rupees so-and-so deposited by your company against 187 sites, 187 number of PDC sites on 24/1/2023 in the APDCL corporate principal account will be finalized and adjusted after taking approval from the higher authority of APDCL. Now, this letter dated 31/1/2023 would bear some relevance, Your Lordship.
31?
1/2023, which is referred to.
Hmm.
Kindly refer to the letter under reference.
Correct.
That Your Lordship will find at page number 348.
348.
348. It is a part of our affidavit in
Is
opposition.
your affidavit, okay. Yes.
This is what was communicated to them. To Shri So-and-so, General Manager, with reference to the above subject, it is to inform you that as per the terms and conditions of the office memorandum under reference, TDC/PDC consumers can avail the waiver of area surcharge amount if their bill is prepared up to 31/12/2022. Lordship will kindly see the emphasis on the word area made here. It's in italics.
Hmm.
Hence, the PDC amount of rupees 124,0616 calculated and deposited from your end against the PDC sites of GTL Infrastructure Limited cannot be adjusted under the ongoing surcharge waiver scheme. So basically, Your Lordship, this is the primary reason why the benefits of the scheme, Your Lordship, could not be provided to them.
And this was given on 31/1/2023.
So that is why this was referred to in the communication at page number 321, which was issued on 25/3/2023.
All their letters are subsequent letters.
Subsequent letter. So this is the primary rejection. So this should ideally have also been challenged, but it has not been challenged in these proceedings. So be that as it may, Your Lordship, what I'm saying,
And they have not, I mean, in spite of having this letter on their hand,
yes, Your Lordship.
they didn't state anything in their letters about this. I mean, sought for a clarification, whether current or this thing.
Yes,
So that is not there.
it is not there.
Only in the last letter they have written.
They have written.
After, I mean.
After the communication of the rejection.
Mhm.
So then the subsequent communications come, Your Lordship.
Mm.
At 321 is the first, 25/3/2023.
Mm. Yes.
Then the other second one at page number 324, dated 27/4/2023. I'll just read this because these are after all technical people writing, Your Lordship. The language is somewhat limited.
Hmm.
In response to your letter dated 7/4/2023 under reference, I'd like to inform you that APDCL allowed for surcharge waiver by the office memorandum dated 2/1/2023. As per terms and conditions of the scheme, all permanent disconnection / temporary disconnection consumers from both low tension and high tension categories were covered under Scheme B, which allowed for waiver of the, this is in bold, Your Lordship, entire amount of area surcharge on payment of 100% principal amount at one time within the period of the scheme. However, it is seen that you have deducted both area and current surcharge on calculation of the reconciliation amount of rupees so and so against the 187 PDC sites paid from your end. Also, discrepancy is found between reconciliation amount paid from your end and the payable reconciled amount calculated from our end. So not only have they not paid the current amount, current surcharge, the principal amount allegedly paid by them, even that does not match what is ideally payable by, what is payable by them according to our records. So on that ground, their benefits under the scheme was rejected. Now, if I may take Your Lordship to three judgments, Your Lordship, on how exemption schemes are to be applied and interpreted. Wood papers to yes. This is Union of India and others versus Wood Papers Limited and another, 1994 SCC 256.
Paragraph?
Paragraph number 4, Your Lordship. So Entitlement of exemption depends upon construction of the expression any factory commencing production used in the table extracted above. Literally, exemption is freedom from liability, tax, or duty. Fiscally, it may assume varying shapes, especially in a growing economy. For instance, tax holiday to new units, occasional rate of tax to goods for persons for limited period or with specific objective, etc. That is why its construction, unlike charging provision, has to be tested on different touchstone. In fact, an exemption provision is like an exception, and on normal principle of construction or interpretation of statute, it is construed strictly either because of legislative intention or on economic justification or of inequitable burden or progressive approach of fiscal provisions intended to augment state revenue. But once exception or exemption becomes applicable, no rule or principle requires it to be construed strictly. Truly speaking, liberal and strict construction of an exemption provisions are to be invoked at different stages of interpreting it. This is important, Your Lordship. When the question is whether a subject falls in the notification or in the exemption clause, then it being in the nature of an exemption is to be construed strictly and against the subject. But once ambiguity or doubt about applicability is lifted and the subject falls in the notification, then full play should be given to it and calls for a wider and liberal construction. Therefore, the first exercise has to be undertaken is if the production of packaging and wrapping material in the factory as it existed prior to 1964 is covered in the notification. Now, Your Lordship, in this case, to get within the ambit of the scheme, first they have to satisfy that they have fulfilled this eligibility criteria laid under the scheme of 2/1/2023. According to us, they do not. And in fact, according to their own admission also, they have left out the current surcharge from it, which was payable by them to get the benefit of that scheme.
They could have clarified
They
it,
could have
clarified it from.
They could have clarified. So once they come within the scheme, then perhaps they might make out a case that yes, it has been rejected. But once you do not make that payment,
The reconciliation about the principal amount and other things that could have been done properly.
done. But prior to 25/1, they made that payment, but that was not done, Your Lordship. And secondly, are we to judgment, yes? Bharti et al. The same, more or less on the same lines, Your Lordship. Paragraph number 8. This is Bharti Telecom versus Commissioner of Customs, 2001-10 SEC 18. Because there were no specific judgments on waiver of surcharge under the Electricity Act, so I found judgments under taxing statutes, Your Lordship. Paragraph number 8, Your Lordship. According to the amnesty scheme, the interest for the period from the date of export and the date of reversal has to be deposited by 31/1/1997. It was not deposited by the said date. It was deposited only on 7/2/1997. There is no room for relaxation or extension of time to deposit the amount of interest. Such scheme or exemption notifications have to be strictly construed. The provision in the notification dated 10/1/1997 for deposit of interest by a specified date has to be interpreted strictly in the manner stated in the notification and on no other basis. It is well settled that in a taxing statute, there is no room for any intendment and regard must be had to the clear meaning of the words, and that the matter should be governed only by the language of the notification, that is by the plain terms of the exemption. So, Your Lordship, this surcharge otherwise is a statutory surcharge. It is not levied by APDCL out of its own whims and fancies. It is framed, it is levied as per tariff orders issued by the AERC in exercise of powers granted under the Electricity Act.
Correct.
So I am just showing tariff orders for 2 different years to show that surcharge is a separate component. It is decided and levied according to the rate for that particular year. That is why there is a difference for area surcharge and current surcharge. Because these are voluminous orders, I have only reproduced the relevant.
I understand, yes.
Very. This is the surcharge payable for the 2 bills which I had taken Your Lordship through. These are the tariff orders applicable for those periods, Your Lordship.
So tariff order keeps on changing.
Keeps on changing
That has
every
to be
year.
decided by
Yes, depending upon the price of, lots of different factors.
Lot of factors.
Lot of factors. Now, thirdly, your lordship had inquired whether there is an alternative remedy.
Yes.
Now, the submission made on behalf of the petitioner
Hmm.
that the statutory forum comes within the ambit of APDCL, perhaps that's not the correct position of law. These forums are created under Section 42 of the Electricity Act.
Electricity Act, yes.
These are statutory forums
Hmm.
directly under the control of the ARC, the Assam Electricity Regulatory Commission. Today, the APDCL is the only distribution company. Tomorrow, if
It will be
it's another
somebody else.
private company also, they will also be, they will also be under the jurisdiction of the state.
These two are different entities.
Different
already.
entities. Different entity. 10,
16,
2022.
22 key regulation.
So, I mean, whoever the engineer in charge, I mean,
Yes.
who will be taking these cases,
Yes.
these disputes.
Because of the
He,
technical
he,
nature,
he's an independent
He's-
body. He has nothing to do with APDC.
nothing to do at all with it.
He may be a representative of the government,
Yes.
but nothing to do with APDC.
Nothing to do with it. So under these regulations, your lordship, two forums are created.
Hmm.
The Consumer Grievance Redressal Forum and the appeal to that goes before the Electricity Ombudsman.
Hmm.
Now the nature of complaints that can be registered,
Where is that?
that your lordship will find at page number 9978.
9978.
78. This is the first, second, third, fourth page, your lordship.
Yes.
Nature of complaint and registration. Perhaps this case would be may be covered by 3.1E, your lordship. Complaints related to billing, collection, etc. Though my primary contention still remains, your lordship, that once they fail to make the payment of the 100% of the principal amount, they cannot get the benefit of the scheme. But if at all there needs to be any reconciliation regarding the figures, your lordship, then perhaps this is the appropriate forum because of the technical nature of the dispute. And otherwise, in electricity matters, your lordship, even the Honorable Apex Court has held, because of the technical nature of the disputes, these forums are the most equipped bodies to deal with such disputes.
So this is the initial forum. Then there is another.
There is an ombudsman.
Ombudsman.
First is the Consumer Grievance Redressal Forum. And against that, if somebody is not satisfied, then they may appeal to the ombudsman. That is at page number 9987. So if they feel that the amount that they have paid, by payment of that amount, the benefit of the scheme should be granted to them, then there is a body, your lordship, because otherwise I cannot make that submission because my mandate is to defend the rejection orders. But because your lordship had posed that question.
No, correct.
I'm
Now only thing is that, if if this court comes to either way, if your submission is, your submission is basically that they have not qualified.
They have not qualified.
Because they did not pay the current charges.
Yes.
And current charges they should have paid.
Yes.
And it's not about like a little bit of reconciliation, but one measure content of the payment has not been made, which has been brought under the waiver scheme.
Waiver scheme.
That hasn't been paid,
That
so
has
they are
not-
not qualified. That is the ground. And they are saying that, no, we have paid whatever as per the scheme.
Yes. Their understanding of
They are understanding of that. And they have challenged their rejection order.
They have challenged the rejection. The scheme itself has not been challenged, and the first rejection of 31(1) that has not been put to challenge. So my submission is that even if you don't pay one single rupee in a scheme which has to be strictly construed as per the law laid down by the Apex Court, then you go out of the ambit of the scheme, and then the benefit cannot be granted to you.
Okay, then we'll hear you after 5 minutes. I'll just rise for 5 minutes, then I'll come back. It has not been paid, and that's why you did not fall under the scheme.
Yes.
That is his argument. Another thing is that as far as the regulatory forum, he's saying that he says it's a statutory body, nothing to do with APDCL. So you had the option of going there also. Yes.
I'll address both this issue.
Correct.
First of all, madam, my learned friend is, what my learned friend has submitted with regard to the current surcharge not being paid. But that's an admitted position. We are not saying that we have paid the amount that's not been adjusted. That's not a fact. So therefore, there is no dispute with regard to that. What I'm trying to show, my lord, from the figures, my lord, now we'll come to that, my lord. Again, that chart, my lord, I'll refer to page 92. Now, the first bill, my lord, as I can see, my lord, there's a difference of ₹2 in odd.
That's fine, okay,
That's
that's
fine,
fine.
no, but in fact, we had paid an extra amount of 1,07,000. That also I can show from the figures. Anyway, that I'll show because logically the principal amount we have calculated page 92. See the column number 4, so we have calculated the entire principal amount which is payable by us. Page 97, your lordship will find the entire.
You're talking about serial number 1.
No,
See-
no, I'm talking about the entire that column, principal amount.
You're showing from page 92, right?
Yes, 92, all these bills we have quoted the principal amounts. We have tallied it, page 97.
Correct.
So we paid the principal amount, total principal amount due
Hmm.
as per our calculation was 1,22 lakhs.
Hmm?
1,22 lakhs. Page 97.
No,
Last
which
thing.
bill you're talking about?
The total,
Hmm?
total 187.
Total?
187.
No, total one has been no. You show me from the bills that, I mean.
No, I'm saying because what I'm trying to say that in this amount, this first bill, we paid about ₹4 less. My learned friend has said, that.
No, that is fine. I mean, now you show me from this serial number 6
Yes,
that he has referred to.
yes.
So he has referred to serial number 6 and he showed me the bill.
Yes,
Bill in page 103.
yes.
So 103, I mean, that is admitted. I think that you are not disputing that.
No, what I'm trying to say, is that we paid more than in fact the principal amount. So this amount of ₹924 was less, my lord. That is not an issue, my lord. We had paid more than that. So that will not be an issue.
Correct. Okay, accepted. That is not an issue.
And
And
second thing, my lord, what my learned friend is trying to say is that we did not pay the surcharge amount,
yes,
the current surcharge.
correct.
That is contention. Lordship will see that figure, total current surcharge, total figure, page 97. We have calculated.
Page 97, yes.
97,
It comes to
22 lakhs.
22 lakhs, yes.
22 lakhs 61,000.
Yes, yes.
Now, my lord, what my learned friend is trying to submit is
So you paid 1 crore 24 lakhs.
1,24 lakhs.
Ah.
My lord, minus we did not pay the current surcharge.
Yes.
So that current surcharge at all, if it was payable, my lord,
Hmm.
which we did not pay as per that, was 22 lakhs 61,000.
Hmm.
Now, here is the dichotomy, my lord. Now, the bills they have raised, they say in their affidavit, my lord, principal amount due is 1 crore 98 lakhs.
Hmm.
So, my lord, if 187 bills is what is there, it is not in dispute. 187 bills, if we have to pay anything additional which we did not pay as per their scheme, their contention, is 22 lakhs only. The current surcharge. Let us assume for a moment, for argument's sake, let us assume for a moment that the current surcharge we did not pay was payable. I will show that it's not payable, but then for the argument's sake.
No, now the argument is that like you do not, I mean, you did not qualify because you did not pay the current surcharge.
Yes.
Correct. Now you'll have to, I mean, now you'll have to show that like from the scheme
Yes.
that no, I mean, we don't need to pay
Yes,
that.
I'll address that. But before that, what I'm trying to say now, my learned friend was saying that just because we did not pay the current surcharge, 22 lakhs and odd, we did not come on the scheme. But the bills they have raised, my lord, or the impugn orders, they claim 1 crore 71 lakhs. So therefore, they are claiming more than what actually not just the current surcharge alone. They are claiming something more, which we do not know. So far as the current surcharge is concerned, my lord, again I'll come to the scheme, my lord, once again.
No, in their affidavit, they have given a figure of, you come to the affidavit 335.
Yes, my lord. That's what I'm saying, my lord. That's the dichotomy. Their figure, my lord, is that.
Their figure is 198.
Yes.
Correct. And they said that the reconciliation will be done.
Pardon me?
They said that I mean, once you pay the amount, the reconciliation will be done, and it in the higher level, it has to be approved. So obviously, like whatever you pay, that may not be the correct figure. That may or may not be the correct figure. So they said they will do the reconciliation, and after that, we'll decide about this.
That is my lord, basic claim.
Hmm.
You say that you will do the reconciliation.
Correct.
Reconciliation against what?
Reconciliation against whatever the figure you have arrived at.
No. We have arrived at the figure as per their bills. How do we pay, madam? How we have paid? We have paid as per the bills, which are before lordship. 187 bills are before lordship. We have calculated those amounts. We have paid the money. They say that your figure is not correct. Our figures are different. Where are those supporting documents or supporting bills to show that their figures are different. They have not provided us anything, neither in the affidavit nor to us. So they are now claiming that the principal amount is 1 crore 98 lakhs due.
And as per you, 1 crore?
Nothing. Principal amount is finished. We paid the entire 1 crore 25. We have already paid. Now they cannot ask this outstanding to be. They cannot include in the outstanding whatever we have paid. They have deducted. So as per them, even after payment of 1 crore 24 lakhs, the principal outstanding amount is 1 crore 98 lakhs.
No, that they are not saying, bro.
Yes, man. If I'm not wrong, now they are claiming a total outstanding amount of 2 crore 95 lakhs.
That includes, because your lordship, they do not get the benefit of the surcharge scheme. It includes both current and area surcharge.
No, this is current in area. If you have
That including that,
No, they are disputing this, I mean, principal outstanding figure.
how did you come to that?
They are saying that how come you have come to a figure of 1 crore 98 lakhs?
yes, sir.
Whereas as per them, as
Yes.
per the bills, the principal amount is 1 crore 24 lakhs. That is his contention.
Number one. Number two, whether this is after payment of 1 crore 24 lakhs or before payment of 1 crore 24. That is, they have not clarified.
So that is fine. I mean, that is in the affidavit. I mean, that play. See, the plea. I mean, the case is something else. Now, if you dispute that figure, that will not do.
No, then my lordship will kindly take up their impugn orders. There also they are claiming 1 crore 71 lakhs. If my learned friend is saying that we did not pay the current surcharge, what is the amount? 2 lakhs. If we failed because we did not pay the current surcharge, but that's not the correct position.
But you did not seek for any clarification from them also.
We sought, this is last
You,
letter.
you sought. I mean, after so many months, the scheme is already over, gone. I mean, in your initial letters, nothing was reflected.
But
See, in their letter, while rejecting, they have specifically taken a ground that you have not paid the current charges, correct? And that is why it has been rejected.
yes.
But your letters to address, I mean, your letters in response to those letters, to their letters, you did not say anything. You did not ask for any clarification also.
But we
Now, ultimately, after 4 or 5 correspondences, then you are asking them when the scheme is already over long time back.
even assuming, my lord, that was relatively done, my lord. Again, lordship will see the scheme then, my lord, once again. That's what I'm saying, my lord. First of all,
The scheme is clear. Scheme is clear. The scheme says arrears.
my lord, scheme says areas that I'll come, my lord. Then what it says, my lord, it further says, that's the most important part is this, my lord. Scheme B, my lord, page 78. On payment of 100% principal amount. So payment requirement is 100% principal amount. They do not say that the entire amount of area surcharge will be waived on payment of 100% principal amount plus current surcharge. That's what they have not said, first of all. Secondly, page 78, madam. So, as per the scheme, madam, as per the scheme, we had to pay 100% of the principal amount. That we have paid. The explanation also we have given why, my lord, the current surcharge we have excluded, my lord. That they have not replied in so many words, my lord. So therefore, my lord, as per our understanding or as per the scheme, my lord, I would go by the scheme, not even our understanding. As per the scheme, my lord, we were to pay payment of 100% of the principal amount, which we have paid. As per the bills which are available with us.
Yes.
Now, my lord, just for a clarification, page 77, my lord, though it is not scheme applicable directly to us, my lord, but lordship will see, my lord, how they, my lord. This is a different scheme, my lord.
Yes.
Here, current surcharge is specifically referred. Scheme adjustment modalities, my lord. 80% waiver of surcharge. 80% of areas there, they have qualified further. 80% of
Now,
area.
they are saying entire amount of area surcharge will be waived on payment of 100%.
No, but adjustment modality second eight scheme.
Yeah, that is adjustment modalities.
But then here, that's what I'm saying, Malad. Here, there are certain clarifications. So therefore, the current surcharge, they're trying to say, that here, the current surcharge payment is also taken into consideration as a modality, Malad, for the second scheme. Here, there's only one scheme, Malad. There are A1 and A2. A2 is regarding 80% of waiver of surcharge, where 80% of the area surcharge amount will be frozen on payment of 50% of payment of the principal and 20% of area surcharge along with current surcharge in the monthly application of the month. So there, the condition was that they specified that current surcharge and area surcharge, some amount you have to pay. Therefore, what I'm trying to say here, Malad, is that here the only qualification in our scheme B was payment of 100% principal amount. There is no other criteria adopted or no other scheme there that you can pay a current surcharge to a certain extent or you can pay area surcharge. There is no, it's only 100% principal amount. Number one, my lord. Number two, my lord, as I have again, my lord, I've already submitted, my lord. I've already submitted, my lord, that current surcharge would mean, my lord, the surcharge amount of a, my lord, ongoing bill, my lord, running bill. We are referring to bills, older bills here, my lord.
In the old bills also, that current surcharge was mentioned there.
It was mentioned, but then that will, but what is actually, what is an
No.
area?
I mean, till that time, I mean, on the raising of that bill, particular year, particular
ma'am.
time.
Yes.
So that was the current
That-
surcharge.
At that point of it was,
No,
my
it
lord.
was.
It was.
Yeah.
But my lord, with the elapse of time. when
So
it-
you'll have to pay on the, I mean, at the rate of tariff at that point of time. So
True,
on that
True,
tariff,
True.
on
I'm
that
not-
tariff, the current surcharge was fixed. So
that's true,
current
my lord.
surcharge was at that point of time, that much, so you'll have to pay that.
So, my lord, that, what is area, my lord? Area is basically payment of accumulated dues.
Yeah, accumulated dues, see, what is accumulated surcharge,
Yes.
which you have not paid earlier. So whatever will be the rates on the basis of that, they'll calculate.
So, my lord, this,
And current surcharge for that particular year,
for the particular bill, my lord.
particular bill, yes,
So, my
particular
lord,
bill.
Since these are old bills, they have all, my lord, come into the category of areas, my lord. That is our contention, my lord. They are all categorized in areas now. Last bill, present bill, if I'm to make a payment, principal amount plus current surcharge. Understandable. But since these are old bills of 2021, 2021, and even 18, these have all fallen into the category of arrears now. Surcharge, the basic thing is surcharge. Current and arrear depends on when it is payable. So the moment it is an old bill, it comes into the category of arrears, because that is what arrears mean. Arrears mean,
That means you're saying that they should have raised a fresh bill on a particular date.
had there been a fresh bill, we would have accordingly paid them.
Hmm.
But yes, perhaps yes. The first thing is that the scheme says 100% principal amount. We have paid the 100% principal amount. Secondly, our contention is that there's no dispute that we did not pay. We did not pay. We are admitting it. We did not pay the current surcharge amounts in those bills, as these, due to elapse of time, had become arrear surcharge by the connotation itself. Arrear, the levy is surcharge. The basic thing is surcharge. Arrear and current will depend on when we are paying it, on when it was payable. Had this bill number page at 103, had it been paid in the month of September 2000, due date was August 2022, then the surcharge amount, current surcharge amount would have been payable. But since these are old bills, these have already fallen into the, these are all old bills, these current surcharge will get accumulated as an area surcharge. So therefore, as per our understanding, we pay the entire principal amount, and the other surcharge part which has become arrear, which has become due, or which was not paid, will be covered under the scheme of waiver. And the waiver scheme only says pay 100% of the principal amount. It doesn't say that on payment of 100% principal amount and surcharge or other dues. It says it's very categorical. So there cannot be a different interpretation from what the circular says.
No, but the other way of looking into is that, so waiver has been given only on areas. Correct. So what can be inferred is that you'll have to pay the current charges along with the 100% this thing.
So that's how we will explain. Your lordship may agree with that. That's a different issue. Whether your lordship will allow that or not, that's
The
another.
current, otherwise that will remain, who will pay that?
No, because this is.
See, some amount will be waived. They have
Yes.
categorized it,
Yes.
that this amount will be waived.
So-
There are two amounts are there. Two amounts are there, one is current and one is arrears. Now they are saying that they will waive you, once you pay the principal amount, they'll waive the arrears amount. Then what will happen to the current charges? Nobody will pay that. Now of course, now you are arguing, your submission is that should have.
It is not paid.
So your understanding is that, I mean, that should have been an arrear only,
Yes, yes.
because you have paid it later
Yeah.
on.
That is my argument. That is my case. That it falls in the category of areas now because since our old bills, had it been a running continuous bill, things would have been different. Number one, my lord. Number two, the submission that has been made by my learned friend is that only because the current surcharge was not paid, I did not come into the scheme. That is not correct. Because they are now trying to say that there are more payment to be made, not just 22 lakhs alone. The current surcharge of this 187 bills, we have calculated this comes to 22 lakhs. Now that 22 lakhs is not what they're claiming to be due. Had they said during the after payment, no, you have to pay this 22 lakhs, we would have paid it perhaps then and there. But what their claim is, initially they claim 75 lakhs. Then my learned friend is saying that figure may not be correct, or that proposition may not be correct at all. Then subsequently they claim 1,71 lakhs. How do we pay that amount? From where do we pay that amount? Where are their bills? Let us assume for a moment that something else is payable. Let us assume for a moment, for argument's sake. It has to be against some bills. It cannot be on thin air. They simply, APDCL cannot come tomorrow, simply and come and say, no, you pay me 1 crore rupees. If you say that, well, X, Y, Z bills are pending, 10 bills are pending or 15 bills are pending, where this amount of 1 crore comes in, I can understand that. That is what we've been asking for all along. So therefore, in my humble submission, first of all, so far as the scheme is concerned, 100% principal amount we have paid, and as per our understanding, or our case is that, it is our specific case rather, that current surcharge, there is nothing called current surcharge with regard to these bills, because since they're old bills, an entire surcharge amount payable will be coming under the category of area surcharge, which is to be waived under this scheme. And since we have paid the 100% principal amount, if they are now trying to say that we have not paid the 100% principal amount, which they are in fact trying to say in the affidavit, because they say the principal amount is 1 crore 98 lakhs. That means they are also trying to contend that 1 crore 24 lakhs, which we have paid as principal, is not exactly the principal. Then they have to show us the figure. They have to give us the figures or the bills, not the figures, but the bills, on the basis of which basis they have calculated. That affidavit is totally silent. It's totally an arbitrary exercise. Simply because they feel that it is not reconciling. What reconciliation they are talking about? Against what bills? What records? Reconciliation cannot happen in thin air. If they say that 110 more bills are pending or subsequent bills are pending, they ought to have brought it on record, saying that this subsequent 50, 20 or 70 bills are pending, you have to pay 1 crore, one more crore. That is understandable. But without being specific as to how these figures have been arrived at, we have given a chart. We have given the bills, 187 bills. We have given a chart also derived from those bills, and we have showed that this is the principal amount. To dispute that, they must come with some alternative bills or figures. Figures are there, but the bills are not there. Simply by saying in their affidavit or in the impugned orders that 1 crore 71 lakhs is payable, now they say principal amount itself is 1 crore 98 lakhs. So their stand has been wavering from time to time. From 75 lakhs in a matter of few days, it went to 1 crore 71. Now it has come, in their affidavit, it has come to 2 crore 95. So their stand itself shows an arbitrary exercise of calculation of their dues or their so-called reconciliation. Otherwise, how these figures jumped from 75 lakhs in a span of few days? It was on 2nd, 8th of February 2023, they say claim 74 lakhs and odd. And on 25/3, it comes to 1 crore 71 lakhs.
Lord, I am not pressing on the 74 lakh figure, Your Lordship. That is regarding the remaining 65 sites, Your Lordship.
No, whether my learned friend is pressing or not, that's another issue. But the point is, my lord,
No, even the letter says so, Your Lordship. The communication is clear. In this regard, it is to inform you that the balance amount of rupees 74 lakhs 22,000 is to be paid against the remaining 75 sites. It should be 65, remaining 75.
even agreeing with that argument, my lord, even for arguments, if I.
Affidavit, you did not clarify that, Mr. Pathak.
My lord, Your Lordship, what has happened?
Mm,
This
uh,
surcharge amount is calculated monthly, Your Lordship. Now, if the calculation comes, it will perhaps be even more.
No, what about the principal amount?
The principal amount, Your Lordship, that is reflected there, it includes both the principal outstanding as well as
You are saying about the 248 sites,
248.
Huh?
It includes both the principal outstanding for the 248 sites.
but that it is not clarified in. your
That is not
affidavit.
clarified, Your Lordship, in the affidavit.
You will have to file an affidavit in this.
My lord, if regarding these figures, Your Lordship, perhaps.
The figures is important because, see, there are two things are coming.
My lord,
One thing is coming is that from the bills, the principal amount comes to something
lord.
to a different figure.
my,
From the bills which have been given by you,
my lord.
correct? The principal amount comes to one figure. And now in your affidavit, you are saying that, see, in your affidavit, you are saying on reconciliation, the assessment made by APDCL for 187 PDC site.
187.
So 187 PDC site, it comes to 198, 1.98 crore. How can it will become 1.98 crore? Your affidavit, there is something wrong. So it says, see, now 124, 1.24 was the calculated principal amount from the bills.
My lord,
A chart they have given, they have calculated it.
my lord,
That is not disputing by you also.
my lord.
But now in your affidavit, you are saying that like principal amount for 180 PDC site is 1.98 crore.
My
So
lord.
how come this figure has come? So he's correctly pointing it out.
Then, my lords, perhaps this entire dispute, since the figures themselves are disputed, Your Lordship, it can be sent back to the.
No, figure is a figure. Figure is important. Another thing you need to reply is that in the scheme, it says only principal amount.
Yes, now
100% principal amount.
there I have a reply.
Yeah, what reply you have?
My response is, if your lordship has the bill, Your Lordship, any one of the bills,
Hmm.
there is no component called principal amount.
No, but in your scheme, you are saying so.
Yes, in the scheme, why
So
the word
if your scheme is ambiguous, then what, I mean, the parties will do?
then the benefit of your lordship, it has to be strictly interpreted why I am saying. If your lordship says the scheme is for the purpose of waiver of the, lordship has correctly said, it is for the waiver of the area surcharge.
Now that issue, okay, that is one issue, that is a contentious issue.
Yes,
Correct. I mean, the interpretation has to be seen.
yes.
But now thing is that as far as this thing is very clear that 100% principal amount.
Principal amount.
So principal amount is what? Principal.
Everything apart from the area surcharge.
Hmm?
Everything apart from the area surcharge.
Mm.
Because if the current surcharge, for example, your lordship is not waived, it has to be regularized in some manner, your lordship.
See, I mean, as the learned friend has pointed out,
My
in the
lord.
other scheme,
My lord.
you have mentioned about current sources.
Yes, if I may just take your lordship to that scheme, that will perhaps clarify.
Hmm.
Page number 76.
Hmm.
So scheme A is for domestic consumers.
Correct.
Now it is presumed that domestic consumers, not all of them may have the financial wherewithal.
No, that is
Pay
the
the
thing.
entire-
Yes, that is there.
It has been distinguished, it
Hmm.
has been sub-bifurcated in three parts.
Hmm.
Scheme A1 is for 100% of waivers.
Hmm.
So how do you get 100% of waiver? The
100%.
entire amount of area surcharge will be waived
Hmm.
on payment of 100% of the principal amount.
Correct.
The same language is used.
Hmm.
Now to fall under the scheme A2,
Hmm.
that is 80% of waiver. How do you do that? Payment of entire principal amount.
Hmm.
Again,
Hmm.
in two equal consecutive monthly installments. So instead of in one go, the same terminology used is same.
Hmm.
The adjustment, your lordship, will be 80% of the area surcharge amount will be frozen on payment of 50% of the outstanding principal and 20% of area surcharge along with current surcharge in the month of application. So it distinguishes between area surcharge and current surcharge.
But you are defining that means that you are defining principal amount.
Why?
You are giving a different definition to principal amount that excludes this two components.
Why I'm saying so, it says 50% of the outstanding principal amount and 20% of area surcharge
Mm.
along with current surcharge. So it says that the component of current surcharge is something different. It cannot be tagged along with area surcharge.
Correct, that I understood. But I mean, from this, what is apparent is that you are giving different, I mean, you are giving it, I mean, definition to principal amount.
Yes,
So
now
principal amount is excluding these two amounts.
no,
So your scheme says that, only the area charges will be waived.
area surcharge will be waived. The scheme from a reading of this clause, Your Lordship, my understanding is the principal amount includes principal, all the outstanding amounts, excluding the current surcharge for the current month.
Yeah,
It
how
says
can you say
current
so?
surcharge in the month of application. I'm reading from A2.
Hmm.
So apart from the current surcharge in the month of application, everything else is included in principal amount. If that be the interpretation, 80% of area surcharge amount will be frozen on payment of 50% of outstanding principal and 20% of area surcharge along with current surcharge in the month of application. So in the month in which you apply, this is in January, for the month of January 2023, the current surcharge applicable for that month, Your Lordship, will also be frozen. On payment of balance 50% of outstanding principal amount along with full current dues within the due date of next bill, frozen surcharge will be waived. So what will be waived is the entire principal amount, area surcharge and the current surcharge for just this month, Your Lordship. And then similarly, if somebody wants in scheme A3, perhaps that will make it clearer still. If somebody wants 50% of waiver of surcharge, Your Lordship, I'll just read this.
Yes.
Payment of entire principal amount in 4 equal consecutive monthly installments. Upon that being done, what happens? On payment of 25% outstanding principal and 25% of area surcharge, along with current surcharge in the month of application. So only
So
for
you are everywhere. You are saying current charges.
Yes.
Current charges needs to be paid. But in
Yes,
this
now-
scheme,
if we come back to the first point, because if we Lordship comes back to scheme A, why there is a distinction? If you want 100% of the waiver of the area surcharge, this scheme will be applicable for domestic A category consumers having area accumulation for 3 or more months as on so and so. Scheme A1, the entire amount of area surcharge will be waived on payment of 100% of the principal amount. So this principal amount, if it is distinguished with A2 and A3, Your Lordship, there only the current surcharge of the month of application, that is January 2023, is excluded. So the rest of the current surcharge up to the month of December 2022, that will be included in the principal amount from the reading of A2 and 3, if that be so. And that is precisely why in scheme B, Your Lordship, since there is no sub-bifurcation into B2 and B3, there is only scope for 100% waiver, it only refers to 100% of the principal amount. Because if Your Lordship then has the bill, any one of the bills at page number 98, for example, just one bill, the one at page number 98.
no 103, come to
Oh,
103.
very well. The one at 103.
Hmm.
There are several components, Your Lordship. Area surcharge is waived. But for current surcharge, if he had been a domestic consumer, this amount for the month of January, for example, this is for the month of November 2021,
So you are taking into account current charges as a different component.
as a different component.
Different component.
Different component.
So if it is different component in your scheme, you are only saying about principal amount.
Principal amount.
You have not mentioned anything about this.
The word principal, Your Lordship,
Hmm.
our interpretation of the word principal is it includes everything apart from area surcharge.
Now, how can you say so?
Because Your
you
Lordship,
show me some material on that. You show me some material on that. And your affidavit also that amount is not, I mean, telling,
I'll clarify that amount. Your
that is not coming.
Very well.
See, now it's the billing details.
Yes, sir.
Billing details, you have this current demand,
My Lord.
then outstanding amount.
My Lord, for example,
Hmm.
let's
So
take the
outstanding amount includes current and this thing, both,
current and
both.
area.
Correct.
Yes, Your Lordship.
So So that becomes different component.
For example, Your Lordship, if we
Mm.
take the interpretation given by the petition,
Mm.
then the word principal
Mm.
also does not include demand charge or fixed charge.
Mm.
It does not include the fuel purchase adjustment charge. It does not include the electricity duty. It does not include the government subsidy. All those components are still there. They have paid those charges. They are saying that only the current surcharge component will not pay. The bill at 103, there are several other components. Even those are not mentioned separately by name.
You clarify these two
Very-
things.
I'll clarify that.
You
with an
clarify this,
Very-
what is principal amount?
Very well.
And secondly, I mean, this affidavit
That figure.
amount
That figure.
that has come, a different figure has come.
I'll clarify that.
So, I mean, I think you have calculated the other sites also.
I'll get that instruction. I'll place it on record.
You
Your
place it on record.
Very
When can you do it?
2 weeks time, Your Lordship. Or 1 week's time, I'll do it, Your Lordship. Immediately after vacation, the matter may be listed. One.
Okay, right, then we'll have to keep it part heard. We
Very
have heard it
Very well.
I
substantially.
might also have a,
Huh?
I might also like to file a reply to that also, but they're fine.
Let them file it, let them
Very
file it and, heard Mr. M. Datta, the learned counsel appearing for the petitioner, also heard Mr. K.P. Pathak, the learned counsel appearing for APDCL. Full stop. Mr. Pathak will submit, will file an affidavit clarifying, the definition clarifying the word that has appeared in the scheme, in the concerned scheme as principal amount. Principal amount, full stop. The Mr. Pathak will also clarify the amount, clarify the figure that has come in the affidavit that has already been filed about the principal amount. Only that figure, you can, because he is disputing that only.
My Lord.
Clarify about this and to the aforesaid effect, the Mr. K.P. Pathak will file an additional affidavit in the matter, full stop. Since the matter has been substantially heard, let the matter be remained as part heard and the matter be listed, the matter and the matter shall be listed on 29th of April,
Very well.
29, man, man.
29th April, or
Whenever it is
or you need
convenient for
some
you.
more time to this thing, first
That
week
is
of May,
Sufficient time, I'll do it.
what is it,
Can-
29th of
Very
April?
well.
Can it be on 30th, man? Or may not, first? Oh, first May will be holiday, man.
Okay, 30th of April,
30th.
30th of April. Okay.
Deeply.
Develop.
You clarify these two
I-
things, otherwise there is some ambiguities.
My Lord.
And in your affidavit also, there are some issues are there. So
Yes,
that you clarify.
Very well. Deeply.
Develop.
P. Goswami, Mr. P. Goswami will apologize. I can see this one.
You was here only?
Yes, I asked my to come.
Lord, in this position, I'm challenging an order which you'll also find in lecture 8 at page 125.
Annexer?
8.
8. Yes.
Page 125.
Is there or not, Mr. Ali?
I'll just confirm.
It says, my lord, this is order passed by the Commissioner of Excise, Assam, in pursuance of the instructions issued by the Election Commission of India in the interstate border meeting held through video conferencing on 24th March 2026. It is hereby ordered that henceforth no transit pass shall be issued for movement of any illegal of any liquor consignment meant for other states through the state of Assam during the period of the model code of conduct for elections to the Assam state ST Council.
So they have debarred for the whole 3 months or something. Model code of conduct will be active till
Declaration of the result and
Hmm.
Now, the question is that, my lord,
But Mr. Goswami is not there, Mr.
I may
Sarab.
make submissions. Two issues I am raising for it, my lord. That whether
It's kind of a blanket stoppage of movement.
restrictions on the interstate movement of the trade and commerce
Hmm.
can be put as per Article 301 of the Constitution of India. Because these liquors are passing through the state of Assam,
Going to a different state.
different states.
Coming, maybe coming from different state also.
It is coming from Arunachal.
Arunachal Pradesh.
I am from Arunachal.
Hmm.
Now, Arunachal, my lord, for going other states, there is no other way. It has to go through the state of Assam. And the strict compliance in the rules it is provided for, that how and the goods can move from the Arunachal Pradesh to the state of Assam. The transit pass has to be obtained from the consignee. Then the permission has to be taken by the consigner in Arunachal Pradesh. It has to be locked. It has to be verified. You do whatever verification is necessary. And earlier also, the Election Commission of India, my lord, in the earlier, page 128. In the February,
My lords, sorry to interrupt, my lords. My senior is on legs, my lord. He has been advised to appear, asked to appear by the department, my lords. He's in court one. PN Goswami will appear, my lords.
So when will be available?
My lord, he was here, my lord, and he.
He was here,
invited-
I can see him because.
Yes, my lord, he was for this matter only, but he has been again summoned to the court one, my lords. Lordship will fix it after 2:30 or 2 minutes. I will try to dispose those matters also.
Mr. Sarab will be available, 2 o'clock will
I
take it.
have to there, my lord, because the,
Yes.
my legal
Yes, because-
Sure, 2 o'clock we'll take it up. then.
Yes, yes, my lord.
Yes. Otherwise, we are here for that only. This
No, no, I
matter.
can see him.
Minutes.
He was here.
All the vehicles are standing in the gate, my lord. They are-
Yes. We'll take it up at 2 o'clock.
Minutes.
Assam, there is no difficulty, liquor is available. It is not banned. Let it be banned in the Assam also till the body code of conduct. Nobody should take liquor till the judge announce.
No, I can see that, I can see that.
Yeah, please, my lord. As per instruction of the senior counsel, Mr. SK Singh, it's out of station. Can you mention it or not?
Okay, Mr. A. Datta, the learned counsel, appearing for, on behalf of Mr. S.K. Singh, the learned senior counsel, appearing for the petitioner.
9.
Petitioner submits that S.K. Singh is out of, is unavailable today to appear in the matter, therefore he prays for some time. Also, let the matter be, Mr.
I accept. I'm for the private respondent, your lordship.
Mr. M. Hussain, right?
I Hussain,
I
MD
Hussain.
I Hussain.
Huh?
MD I Hussain.
MD, yes, MD I Hussain is present for respondent number 4. No,
Four,
oh
four.
yes, respondent number 4,
Ramchandra Sahani.
respondent number 4. Let the matter be listed after the vacation.
Lordship. If-
Yeah, let the matter be listed in the month of May, first week in the month.
Like- Bipul Thakur, no? Bipul Thakur is this one.
10, item number 10.
Lordship, we filed our affidavit in reply yesterday, Lordship. It may be record our Lordship.
It is not in record.
Lordship.
Ten is Bipul Thakur, yeah.
You are
D. Datta, Lordship.
MSD Datta, learned counsel, appearing for the petitioner, submits that she has filed an affidavit in reply in the instant case. However, the same is not on record. Not on record. Let the matter be fixed in the month of May.
May I tell you, Lordship? Lordship, in this matter, notices were issued, thereafter, affidavit is yet to be filed.
In this case, Lordship, I have received one instruction. Lordship would like to peruse it.
You know, what is the instruction?
Lordship, in this case, the department Due to the ongoing election, department requested to pay for 8 weeks time. Lordship.
But it's a 2023 matter.
Yes, Lordship. Some developments are there, Lordship. We have written to the district commissioner also.
The 2023 matter, I mean, you have not filed any affidavit as yet. Now you are coming up with an instruction saying that there is election. Okay, we'll post it after the vacation. No? Heard Mr. N. Pathak, the learned counsel for the petitioner, also heard Ms. G. Hajarika appearing for respondent number
And for respondent number 1. Lordship.
1. Is it revenue department?
Yes, sir.
Respondent number 1. Goswami is appearing for us. Huh? Mr. N. Goswami is appearing for respondent number 2 to 5. Ms. G. Hajarika has submitted that she has received certain instructions and would like to file an affidavit in the matter. Let the matter be listed in the month of May.
Deeply.
She would like to file an affidavit and then write praise for some time, huh? Write death sentences.
My lord, in pursuit of the Honorable Court Order dated 16/2, my lord, I have filed an additional affidavit.
Yes.
There is a direction to annex all the documents relating to my execution case and the map of the relevant, my lord, the land.
Okay.
My lord, it's a disputed that they say,
So are you going to file any reply to this?
Want to file rejoined.
Yes.
my lord, only prayer is this, my lord, initially, the beautification project that was took place in 2024. At that time, my lord, they illegally encroached my 1 katha of land out of 7 biga, 1 katha 10 lesson. Now, in due course of my lord, time,
Some more encroachment.
more than almost complete, but they have come with a affidavit in a respondent number 2, that is the circle officer. They saying that the land is belong to the government land. So on that view, the Honorable Court direction was given to me to file a detailed affidavit. I have filed a detailed affidavit with all annexes, from which it is very clear the land
Your right and title is clear
Already.
from your documents. That's what they're saying. Now, maybe they are disputing that. So let them file an affidavit in this.
But they are one of the only the development authority. They are the executing authority. But the acquisition authority is the deputy commissioner. So far the one of the NOC is concerned, that is given to, I have been informed that NOC has been issued in respect of the government. So I have no objection to if the project is confined to the government, but if it is going to that extent also. I have
Chakraborty is
also-
appearing for whom?
Madam, let an affidavit be filed by the revenue department also.
You are appearing for whom?
I'm for water resource department.
Water Resource Department. The Water Resource Department, how Water Resource Department is involved?
My lord,
because
the
they are
project.
executing the project.
But
They're
we have-
executing the project.
But we have received a clearance certificate from the revenue authorities, my lord.
Who is appearing for the revenue authorities?
One of people were filed also.
So you filed an affidavit also?
One of
After
it-
this, after this.
No, that is there. I mean, now since he has filed certain documents clarifying that he has right and title in the land, so you'll have to respond to that.
And this is my affidavit, my lord, from the very beginning. It is all in consonance with my pleadings, whatever I have taken in her. It is nothing is my deviation.
So you have already taken those pleadings.
Yes.
Okay, Mr.
My
Hard,
prayer, my
Mr.
lord,
P.
is without
Mahanta,
being
the
heard in early, my lord, then later
P.
we have to
Mahant-
finish, my lord.
P. Mahanta, the learned counsel appearing for the petitioner. Also heard MSP Chakraborty for respondent number.
It is, my lord.
One,
4.
uh,
Respondent number
1, 3,
1, 3 and 4.
yes. ma'am.
No, 4 no.
One, four.
1, 3 and 4. 1, 3 and 4.
One,
And
three.
N. Goswami for respondent number
2 and 5.
2 and 5.
That's it.
Director of service is required.
But because.
Who is
they are-
appearing for them?
Yes, my lord, the already copy has been served. Their entrance, appearance is very necessary because, my lord, the cadastral, my lord, pillar, that has been updated by this, my lord, during the course of the execution of the project.
Who is
So,
appearing for director of service? Nobody is there.
I have served the copy, my lord. Director, earlier when I have served the copy, my lord.
Anyways, let them file file affidavits. Okay. None appeared for respondent number 6, full stop. The learned counsel appearing for respondent number 1. 1,
3 and 5.
3,
And-
3 and 1, 3 and 4.
4 as well.
1, 3 and 4, as well as the council appearing for respondent number 2
And
and
five.
2 and 5 submits that they would like to file an affidavit on, they'd like to file affidavit in oppositions to the additional affidavit filed by the petitioner. Therefore, praise for 2 weeks' time. Let the matter be listed.
So one date may be begun, my lord, otherwise it was for a long pending.
Let the matter be listed on 7th of May.
7th of May. My lord. Masam.
13,
My lord, this is basically a partner matter in some other bench. It's
Yeah.
wrongly listed here.
which bench?
It's in
Okay. The,
here for the respondents.
the order, okay, right, Mr. A. Hussain is present on behalf of the petitioner, and Mr. D. Chaudhary is present on behalf of respondent number?
One.
Respondent number 1. Mr. Chaudhary submits that this matter was substantially heard before another bench, and the matter was kept part heard. Full stop. Seen the order dated 10/2/2026, it reveals that the matter was kept part heard before a coordinate bench. Raised to list this matter in the appropriate, before the appropriate bench.
Clarification.
After the vacation.
Please, Your Lordships. Your Lordships, I'm appearing for the petitioner in this matter. Your Lordships, the respondents have filed their affidavit, counter affidavit in this case. They filed the reply. Your Lordships, I'm seeking for one date. On that date, we'll address the arguments in this case. Your Lordships, may just give us one final date for final arguments.
You are appearing for whom?
Manoj, I am for petitioner in this matter,
Your Lordships,
along
petitioner.
with Mr. Ishan. I'm appearing, Manoj. Counsel for petitioner. Manoj, my associate is Mr. Ishan. I'm for petitioner. Karan Bharadwaj, Manoj, item number 14.
Okay, right. Karan Bharadwaj, the learned counsel. APS for the petitioner through VC. Full stop.
Manoj, I can assist Your Lordships if Your Lordships permit me. This is a very small issue which is involved. I'll not take more than 5 minutes.
And who was the other person who appeared? He's disappeared.
Manoj, Mr. Ishan appears with me, Manoj. I requested him to make a request. I was on legs before a coordinate bench, but I timely.
So you were seeking some time, right?
Manoj, he was seeking on my behalf that
then-
I was in difficulty, but I'm here, Manoj. I'm so
Okay,
sorry.
and respondents who is appearing?
Respondent number 5, Lordship. S. Yasmin for on behalf of M. Sharma, Lordship.
Right, S. Yasmin on behalf of Mr. M. Sharma for respondent number 5. And Mr. S.K. Hazarika for respondent number 1, 2, 3, and 4. 1, 2, 3, and 4. The learned
The state is
counsel
appearing.
for the petitioner submits that he has filed an affidavit. He has already filed an affidavit in reply in the matter, but
Yes.
however, he seeks some accommodation to prepare the matter for argument. Full stop. Let the matter be listed after the ensuing leave vacation. Prayer is allowed. Let the matter be listed after the ensuing leave.
Lordship, a copy may be served upon us. We have not received the copy, Lordship.
Copy you have not served.
Copy already been served.
Manoj, only we have not filed any. Just an application was filed. That application has already been served. Otherwise, apart from that, there's no application.
Please
We
serve a
have
copy.
received
The
their.
respondent number, counsel for respondent number is saying that she has not received the copy. So you serve a copy?
Manoj, please,
Copy of what? Affidavit in
Manoj, can I pray for some?
So copy of affidavit in reply, you submit a copy to, you serve a copy to the respondent.
Please,
okay?
Lord. Please, Lord.
Respondent number
Please.
5, respondent number 5.
Please,
You
Lord.
serve a
Can I
copy-
pray for a shorter date if the Lordship may deem appropriate?
Sorry,
My
won't be possible. We have all motion days because we are having this.
Manoj, my vehicle is in their illegal
vacation
custody.
now. We are
It has
going to
been.
have some vacation. Correct, we can't be helped. Can't be helped. Not
Please,
before the big vacation.
Please, Lordship. That's all.
Lordship, in this medical report has not come, Lordship. One medical report was called for, Lordship, that we are yet to receive, Lordship. So, Lordship, immediately after vacation, Lordship. It will come from the jails. or
Bail pick the application keeping pending for so much of time is difficult. I mean, you know, I mean, what is happening, what is going on. So it was,
When statutory violation grounds are there, Lordship, only because Lordship, only he is suffering from some diseases. That is why they are seeking bail. And
Lordship, earlier also,
just 22/2026 notice was issued.
yes, Lordship.
So we are already a month. Okay, we'll just skip it after the, immediately after the
immediately after
vacation.
vacation.
A date may be fixed, Lordship, on
Immediately after
23rd.
vacation, okay. Heard Mr. M. Dev, the learned counsel appearing for the accused applicant, also heard Mr. P.S. Lakar, the learned APP for the state. And U. Chaudhary for respondent number 2. The Mr.
decide now with
Mr.
Rahman.
Lakar submits that
Going
updated case diary in the state case is yet to be received and therefore praised for some time. Let the matter be listed on on 23rd of April.
Yes, Lordship.
On 23rd of April.
Without fail, Lordship, a medical,
I'll bring this.
very serious condition.
Yes, bring-
Oblige.
okay. Election Commission, what are the instructions you have issued?
For the manual and model code of conduct, Lordship,
Hmm.
this is the, I just provided.
No, manual, which model?
Manual, Lordship. There is a. Page 93. There is a chapter on ban on sale of liquor, Lordship.
Ban on sale of liquor.
Liquor, Lordship.
This is from where? Which, I mean,
This is the manual for model code of conduct.
model conduct, code of conduct changes, no?
Lordship, no, but this is this procedure, Lordship. As per section 135C of the Representation of People Act 1951, Lordship.
Hmm.
Only section 135C of the Representation of People Act, Lordship, 1951, Lordship.
Hmm. No, under that power, you have issued this, right?
Lordship.
Under that power, you have issued this.
This is, I'm just bringing the Lordship. Election Commission has limited instruction, Lordship, as regards controlling of illicit sale of liquor, Lordship.
Hmm.
So as this in
No, under this power, you have issued this model conduct, model conduct, code of conduct.
during the election, when the once election notification is issued, Lordship, the
Hmm.
model code of conduct
Conduct
comes into
play.
existence.
Okay. Here also model conduct, code of conduct you have issued when?
Lordship, model code of conduct
For this year?
immediately when a notification for the election was announced, Lordship.
Hmm.
Election notification.
So is it page
7th of March.
82, Mr. Saraf? Is it page 82?
Page 82, Lordship.
Page 82?
Yes, Lordship.
Yes.
16th of March and 26th, Lordship.
Yes, 16th of March. Yes.
Lordship.
Now, this is all, right?
That's it.
This is all.
Yeah, Lordship. Once the model code of conduct announcement is made, Lordship,
Correct.
model code of conduct comes into being and it is
Hmm.
stays until the election results are declared.
Correct. Is there anything which deals with sale of liquor here?
That's it, Lordship. The guideline that I have submitted, Lordship.
Hmm.
I'll just refer to section 135C of the Representation of People Act.
Section?
135C of the Representation of People Act 1951. The Act of 1951, Lordship, not 1950, Lordship.
135?
C, Lordship.
Yes.
It says liquor not to be sold, given or distributed on polling day.
Hmm.
No spirituous, fermented or intoxicating liquors or other substances of a like nature shall be sold, given or distributed at a hotel, eating house, tavern, house or any other place, public or private,
Hmm.
within a polling area during the period of 48 hours, ending with the hour fixed for conclusion of the polls or any election in that polling area. Any person who contravenes the provision of subsection 1 shall be punishable with imprisonment for a term which may extend to 6 months or with fine, or which may extend to 2,000 rupees or with both. When a person is convicted of offense under this
Yeah,
section.
correct. That we got.
basically,
Yes.
Complete ban is as regards to 48 hours, Lordship. And other than that, Lordship, there is a direction to the excise department. There should be a monitoring and control as regard sale of illicit liquor, Lordship.
Hmm.
So under that, how they,
No, where is the direction?
Lordship, my senior counsel is already annexed, Lordship,
Hmm.
certain provision of the
Lordship, in page 86 of the writ petition, Lordship.
Page 86, yes. Yes, page 86 where?
Last long, point number 6, activities for expenditure monitoring and enforcement of MCC.
Hmm.
Flying squad, FST video team intensive checking for liquor, cash, contraband, drugs. Flying squads of excise department of checklist illicit traffic of narcotic drugs to be immediately activated after announcement. So once the MCC is announced, this should be activated, Lordship. Subsequently, Lordship, page 88,
Mhm.
point number 21, the following types of activities will require prior permission of the commission. That is, fresh auction of liquor vans, etc. cannot be held even if annual auction time falls within the model code of conduct period. Where
Correct.
necessary, the government should take interim arrangement as provided in the respective law. Therefore,
Yes.
Lordship,
Hmm.
in page number 89,
Hmm.
that is point number 10, Lordship.
Permission for
Permission for
allotment.
allotment of liquor vans, finalization of wholesale liquor sale, major auction.
So I mean, these
These are the
provisions,
general.
these provisions doesn't cover his case.
No, Lords, that
Then-
is not our.
Then anything else here? As far as
And
transit, something is there?
number is, last point is number 92, which indirectly is the 135, Lordship, this is 135C,
Hmm?
which has been, page number 92, number 7, Lordship. No
92.
spirituous, fermented or intoxicating liquor or other substances of a like nature shall be sold, given or distributed at a hotel, eating house, tavern, shop or any other place public within a polling area during the period of 48 hours ending with the hour fixed for the conclusion of polls or any election in the polling area. Dry days shall be declared and notified under the relevant state or union territory laws as is appropriate during 48 hours ending with the hours fixed for conclusion of polls as indicated in the commission's notification respect to polling day for an election in the polling area where elections to parliamentary constituencies, legislative assembly constituency.
So it is basically for selling, distributing
Lordship.
in hotel or eating house,
There should
whatever.
be, there should be
There should be some restriction where in 48 hours.
Lordship, 48 and along during the entire model code of conduct, there should be a monitoring so that illicit liquors are not sold and the environment is not, Lordship, disrupted because we have seen in many cases using of illicit
I mean,
liquors,
liquor
the
is distributed, this and
the
that.
position and all, Lordship, they have to influence the voters, Lordship.
Mhm.
So it is basically to control illicit liquor selling.
Correct. Now tell me one thing. I mean, like this, this, one second, sir. One second. This has been issued as per your instructions.
Lordship,
The impugn order.
what I am, Lordship, they have,
Huh?
that the excise department issued, Lordship.
Correct, it has been specifically stated that in pursuance to instructions issued by the Election Commission of India, in inter-border meeting held through video conference, it is hereby ordered henceforth. So do you have any instruction on this?
No, Lordship, so actually it's like the specific instruction that such for interborder transport that has been stopped. I have no such instruction as of now, Lordship. But as regards my.
So you don't have any instruction on your hand.
Upon hand,
You don't have any
No,
instruction.
no, that I'll let me.
This copy was served to you earlier.
Yes, Lordship, that has been.
So have you taken any instructions?
I
from
have,
them?
I have asked my superior Lordship, but I was informed that as regards monitoring, that has been directed that whenever the model code of conduct is announced, Lordship, basically the excise departments are directed to monitor the entire conduct, Lordship. There should not be any illicit sale of liquor. But
So basically illicit sale of
illicit sale of liquor, that has been no
liquor.
direction. Not complete ban on, Lordship, movement. That has not been any, I have not received any such instruction, Lordship.
So you don't have any instruction. You tried to get the instruction, but
As a written instruction, I have not received that there is any instruction from our end to ban illicit movement, movement of intercept drugs, Lordship. So.
Whether model code of conduct or not model conduct, illicit liquor sale cannot be there. Monitoring has to be done.
okay, now
There are various provisions which has to be followed strictly. We are not on that mode. You should not monitor. You should monitor. Illicit sale of liquor should not be there. That can be in Assam also. Assam also, when the liquor is being sold, illicit sale may be there. I am not on that. They should take all efforts to be made that illicit sale of liquor should not be there. But under use of that power, can you stop the movement of the liquor from Arunachal Pradesh to the other states? What is the effect, Mr. Lordship, can you see? The liquor from Arunachal Pradesh is not going outside. Assam liquor can go outside. The persons who are manufacturing in Assam, they can sell liquor to outside. But from Arunachal Pradesh, the liquor will not come across Assam because there is no other way. It cannot go to the outside states. Because there are sufficient provisions under the Act. The transit passes, the permission, whatever.
The kind of vehicle.
Vehicle,
Yes.
everything. And I'm not saying that they should not follow strictly. They should strictly follow, monitor. Everything should be examined. But can they say that for 1.5 months or 8 days or 10 days, my vehicles are stranded at the checkpost. They are all standing there. Valid transit passes are there, everything is there, the vehicles are not going. And 301, as your lordship is aware, Article 301, if your lordship takes the trouble. 301, Article 301, yes. Your lordship, can you see below?
Yes.
Subject to the other provisions of this part, trade, commerce, and intercourse throughout the territory of India shall be free. Now, your lordship may kindly see 304. Notwithstanding any content in 301 and 303, the legislature of the state by law may impose the goods imported from other states, we are not concerned, my lord. B, impose reasonable restrictions on the freedom of trade, commerce, and jurisdiction within the state where there may be so and so, provided that the bill or amendment for the purpose of clause B shall be introduced or passed by the legislature of the state, not extend without the permitting vice president of the president. So even reasonable restriction, and that too by
It has to by way of a law.
law, and that too bill cannot be introduced without the previous sanction of the president. Now by executive instructions, the judgment, executive instructions, you cannot impose any restriction on the freedom of trade, commerce, and intercourse. You can't put the executive instructions. Your lordship, can you see, my lord? India Cement.
Yes, para.
Para 11. The last part, my lord. Just before para 12.
Yes.
The true purpose of the restriction contained in para 13 of the Constitution, as elicited in the different decisions of the Constitution bench, is that the restriction provided for in Article 301 can, within the ambit of the limited, or can be limited by law made by the Parliament and the state legislature. No power is vested in the executive authority to act in any manner which affects or hinders the free essence and goods contained in the scheme of Part 13 of the Constitution. It is equally clear that the declaration contained in Part 13 of the Constitution is against creation of the economic barriers and or pockets which would offend against the free flow of trade and commerce. Thereafter, your lordship may see para 13, the last 3 lines.
Yes.
The reasonable restrictions contemplated in Part 13 have to be backed by law and not by executive action, provided the same are within the limitation as prescribed in the Part 13. Now, my lord, the section which has been produced before, read by learned friend 135, that speaks of only 48 hours.
48 hours and monitoring.
And monitoring is there. Total ban is for 48 hours in the state. There will be like Gandhi Jayanti dry day, this day dry day. to total ban. And monitoring, I'm not stopping that your monitoring should not be there. I said full monitoring should be there. But how you can pass an order that through transit passes, there shall be no movement of the liquor passing through the state of Assam to the other states. That will have a far-reaching consequences, my lord, because you are discriminating between the liquor which has been produced in the state of Arunachal Pradesh.
And other states also, Meghalaya, maybe Meghalaya.
Maybe Meghalaya, and the liquor which is produced in the state of Assam. The state of Assam manufacturers can send outside, and the Arunachal Pradesh person cannot send to the outside.
Yes, I got your point. I got your point. You'll get a, I mean, opportunity to reply. Let him submit, Mr. Parangam Goswami. Where did you get this
My
power?
lord, my instruction is that in that video conferencing with the election commission, we are directed to pass this order, my lord. Accordingly, we have passed this order. And in justification of this order, my lord will have to also, my lord, make a balance between the private interest of the petitioner and a free, fair election in the state, my lord. He may claim Article 300A, he may claim Article 19. That I will answer, my lord. This is the data, my lord, we have collected about illegal liquor seized, my lord. This is a detailed seizure report of liquor not meant for sale in Assam. All these liquors were transported through the state of Assam for another states, meant for
But you said like some direction you have received. Have you received any direction? Can you show me?
No, there is no written direction. In the video conferencing, my lord,
No,
election,
I mean, the datas are fine.
my lord,
Datas
you
are
kindly see
fine.
this data, how it has hiked, my lord. From first one is my second column, 1/1/2026 to 14/3, up till 14th of March. My lord, this was the liters cheese, my lord. Total 65,000, 6,582. From March, my lord, 15 till date, my lord, till today, this is the amount, my lord. 37,851 liters of illegal liquors seized, my lord, shown to be meant for other states, my lord. But we should be more concerned with, my lord, free and fair election, not the private right of selling liquor of the petitioner, my lord. And as I have already submitted, my lord, this is an order not to be enforced till, my lord, the election results are over. It is still the date of counting, my lord. Sorry, voting. That is on 9th, my lord. We are only another 5 days left. Another 5 days left, my lord. From 7, my lord, there will be absolute ban. There will be dry day, absolute ban of sale of liquor. Another 3 to 4 days left, my lord. So petitioner should not have an apprehension that it will be restrained till the counting is over, my lord. Secondly, my lord.
But this order says something else. Order said,
Yes, my specific.
order said that it is being enforced.
Yes,
on model code of conduct.
my specific instruction from the commissioner secretary and I'm giving an undertaking before your lordship that immediately after 9th we will withdraw this order, my lord. We're just waiting for the vote to be cast, my lord. And secondly, my lord, on the issue of Article 300A and Article 19(1)(g, my lord, we all know that trade in liquor is held to be, my lord, res extra commercial. I'm coming to all. Trade in liquor is, my lord, not a fundamental right. It has been considered to be res extra commercial offense, business in offense, my lord. So nobody can claim as a matter of right of doing trade in liquor. For that, my lord, I will just rely on a judgment of the Honorable Apex Court. Therein, my lord, 300 and we have not created absolute ban, my lord. It is for the time being till 9th only. This is a famous judgment, my lord, 1995, 1 SCC, Khodai Distillery, my lord.
Yes, which paragraph, Usami?
Yes, I'm coming to it. Just a minute. Paragraph 8, my lord, may kindly peruse. Paragraph 8.
Yes.
Two incidental questions which therefore arise are whether a monopoly for the manufacture, trade or business in liquor can be created in favor of the state and whether reasonable restrictions under Article 19(6) of the Constitution can be placed only by act of the legislature or by subordinate legislation as well. It is contended that a state cannot carry on trade of liquor under Article 47 of the Constitution if the law on the subject is considered to be law under Article 19(6). It has to be on the basis that a citizen had got a fundamental right to trade in liquor. If the law is that a citizen has no fundamental right, then Article 19(6) cannot be applied because the said article applies only to those rights which a citizen possesses. When a citizen cannot do under Article 19.1, the state cannot do under Article 19.6. Secondly, it is submitted that assuming the state has got the power to carry on trade in liquor, rehearse Article 19.6 and under Article 298 of the Constitution, the power under Article 298 cannot extend to the trade in liquor. This is also because the union government has no executive power to trade in a commodity which under Article 47 it is enjoined to prohibit. It is relevant, my lord. My lord, kindly take note of.
But this is like state.
I'm coming to it, my lord. Just
yes.
for the background, my lord, I'm showing this. It's very
Yes.
relevant judgment, my lord. Paragraph, my lord, 13, my lord. In paragraph 12, my lord, Article 19.1G has been quoted, discussed. Then we skip to 13, my lord. Article 47, which is one of the directive principles of the state, reads as follows. This is quoted, my lord. We can skip, my lord. This article enjoins upon and in turn enables the state to take measures to raise the level of nutrition and the standard of living of its people and to improve the public health. Towards this end, the state is required to bring about prohibition of the consumption of intoxicating drinks, drugs, which are injurious to health. The prohibition may be complete or partial, and it would also include regulation. It cannot be disputed that liquor is one such drink. Paragraph 14, Article 298 of the Constitution provides as follows: power to carry on trade, etc. The executive power of the union or of its state shall extend to carry on of any trade or business and to the acquisition, holding and disposal of property and making of contracts for any purpose, provided that the said executive power of the union shall, insofar as trade or business or such purpose is not one with respect to which Parliament may make law, but be subject to each state to legislation by the state, and the said executive power of the state shall, insofar as trade or business of such purpose is not one with respect to which the state legislature may make law, be subject to the legislation by Parliament. Thus, both the union and the state governments have within their respective spheres the power to carry on trade or business. 15 is relevant. Article 300A provides that no person shall be deprived of his property save by the authority of law. It is disputed that if a citizen is carrying on the business according to the provisions of law, his business cannot be taken away save by authority of law. If such a law is enacted to further the purpose, whether Article 19.6 or 47. Article 301 reads as freedom of trade, commerce, and intercourse. Subject to the other provisions of this part, trade, commerce, and intercourse throughout the territory of India shall be free. The right given by this article to freely trade, commerce, and intercourse throughout the territory of India is undisputedly subject to same restrictions as is the right under Article 19.1G. Apart from the restrictions placed on right under Article 301 by the provisions of Article 19.6, 47, 302, and 303, the provisions of Article 304 also place such restriction on said right. So do the provisions of Article 305 so far as they protect existing laws and laws creating state monopolies. The provisions of the aforesaid articles, so far as they are relevant for our purpose, read together, therefore make the position clear that the right conferred under Article 19.1G is not absolute. It is subject to restrictions imposed by other provisions of the Constitution. Those provisions are contained in Article so and so, so and so. Now, my lord, if we go to the ratio of this judgment, my lord, paragraph 60.
Paragraph?
60. After discussing all previous judgments, my lord,
Yes.
we may now summarize the law on the subject as culled from the aforesaid decisions. The right protected under Article 19.1 are not absolute but qualified. The qualifications are stated in clause 2 to 6 of Article 19. The fundamental rights guaranteed under Article 19.1A to G are therefore to be read along with the said qualifications. Even the rights guaranteed under the Constitution of the other civilized countries are not absolute, but are read subject to the implied limitations on them. Those implied limitations are made explicit by clause 2 to 6 of Article 19 of our Constitution. The right to practice any profession or to carry on any occupation, trade, or business does not extend to practicing a profession or carrying on an occupation, trade, or business which is inherently vicious and pernicious and is condemned by a civilized society. It does not entitle citizens to carry on trade or business in activities which are immoral and criminal and in articles or goods which are obnoxious and injurious to the health, safety and welfare of general public. That is res extra commercium, outside commerce. Therefore cannot be business in crime. There cannot be business in crime. That is res extra commercium. Potable liquors, paragraph 6, C. Potable liquor as a beverage is an intoxicating and depressant drink which is dangerous and injurious to health and is therefore an article which is res extra commercium being inherently harmful. A citizen has therefore no fundamental right to do trade or business in liquor. Hence, the trade of or business in liquor can be completely prohibited. Article 47 of the Constitution considers intoxicating drinks and drugs as injurious to health and impeding the raising of level of nutrition and the standard of living of the people and improvement of public health. It is therefore ordains the state to bring about prohibition of the consumption of intoxicating drinks, which obviously include liquor, except for medicinal purposes. Article 47 is one of the directive principles which is fundamental in the governance of the country. The state has therefore the power to completely prohibit the manufacture, sale, possession, distribution, and consumption of potable liquor as a beverage, both because it is inherently a dangerous article of consumption and also because of the directive principles contained in Article 47, except when it is used or consumed for medicinal purpose. For the same reason, the state can create monopoly either in itself or in the agency created by it for the manufacture, possession, sale, and distribution of liquor as a beverage, and also sell the licenses to the citizens for the said purpose by charging fees. This can be done under Article 19(6) or even otherwise. For the same reason, again, the state can impose limitations, restrictions on the trade or business in potable liquor as a beverage, which restrictions are in nature different from those imposed on the trade or business in legitimate activities and goods and articles which are res commercium. The restrictions and limitations on trade or business in potable liquor can again be both under Article 19(6) or otherwise. The restrictions and limitations can extend to the state carrying on the trade or business itself to the exclusion and of the elimination of others and or to preventing to itself the right to sell license to do trade or business in the same to others. When state permits trade or business in a potable liquor with or without limitation, the citizen has to carry on trade or business subject to the limitations, if any, and the state cannot make discrimination between the citizens who are qualified to carry on the trade or business. The state can adopt any mode of selling the liquor for trade or business with a view to maximize its revenue so long as the method adopted is not discriminatory. The state can carry on trade or business in potable liquor, notwithstanding that it is an intoxicating drink. And Article 47 enjoins it to prohibit its consumption. When the state carries on such business, it does so to restrict and regulate production, supply, and consumption of liquor, which is also an aspect of reasonable restriction in the interest of general public. The state cannot be on that count. The state cannot on that count be said to be carrying on an illegitimate business. The mere fact that the state levies taxes or fees on the production, sale, and income derived from potable liquor, whether the production, sale, or income is legitimate or illegitimate, does not make the state a party to the said activities. The power of the state to raise revenue by so and so. Paragraph K, my lord. The state cannot prohibit trade or business in medicinal and toilet preparations containing liquor on so and so. Then paragraph.
No, you are not prohibiting, sale.
We are regulating, my lord.
You are not prohibiting.
We
you
are
not-
regulating
no,
the
you are
trade.
not regulating your own liquor also. What you are doing is basically, see, there is a provision, under the Excise Act only, a transit permission should be given.
Yes.
So transit permissions, how it should be given, there is a prescribed provisions.
For
are
the
there.
time being, my lord, we have imposed restriction on that, my lord.
So how can you do that? How can you do that? That too, that election commission has stated that there is no such instructions.
No, election commission has, my lord, in the video conference, they have specifically instructed
No,
us to issue.
where is that? Now video conference, this is not backed by any law. Only one executive order has been passed and that thereby the whole transit you have been stopped.
Yes, my lord.
That
Till
even-
9th, my lord.
see that Mr. Goswami, that creates other things also. So as you are saying that the spurious liquor and people's interest has to be seen, then you'll have to see the interest of the other states also. But yeah,
Yes,
those are your neighboring states
Well, this
and
is
they
a-
are doing business.
Yes.
If you stop, the transit, I mean, you have all the right to do whatever, I mean, protection you want to take. You can take it. You can take it, you can check it,
My lord,
whatever,
clearly
I mean.
appreciate, but despite that,
No, no, but, and that, I mean, that you haven't done, but like you have the whole, I mean, the blanket, stop
Yes.
you have done.
reason behind, my lord, will kindly say, there are mechanism to check. But in that mechanism, we could find out 37,000 liters, my lord.
I mean,
Illicit liquor, not meant for Assam. It was from other state to other state, through the state of Assam. That's why, my lord, will kindly
so
also
whether you
appreciate
have,
one thing, my
whether
lord.
we have passed any order in state of Assam, similar order. I mean, similar order means I'm saying is that like stopping anything, sale of liquor. I mean,
lord will-
have you formed any squad to
Yes,
check
yes,
these things?
those are already there.
All these things are there.
These are already there.
Hmm.
For a state liquor manufacturer in state of Assam, my lord, there is no question of, my lord, illegal trade.
Hmm.
These are neighboring states, my lord, where the excise duties are very less. So usually, my lord, from Meghalaya and Arunachal mostly,
Hmm.
these liquors come into Assam and illegally sold in Assam and sold in Assam. But difficulty is, my lord, will kindly appreciate, this is an election time, my lord. This ban is not absolute. It is not for in perpetuity, my lord. It is till 9th. Only till 9th it is, this ban is
Yeah,
imposed. my
ban,
lord.
I mean, see,
They
if,
can wait for
if
5
you
days.
restrict something, that has to have a backing of law.
This is the backing of law,
I
my
mean,
lord.
I didn't see any backing of law, Mr. Goswami.
My lord, kindly appreciate. In
I
respect of
didn't see,
liquor,
no, I didn't see any backing of law in issuing this order.
in respect of liquor, my lord has seen, my lord, that Article 19(1).
But they are not selling it also, they are just passing it through it, passing it through it.
In the
Now
process,
you
my
have,
lord,
no, correct, you have given this, I mean, some list you have given. But whether you can say that this has come from state of Arunachal
Yes,
Pradesh
yes,
only?
yes.
I mean, where is the data?
I can give that data, my
No,
lord,
no,
because I
where
thought,
is
my
the
lord,
data?
this will be sufficient,
No,
because my lord will see the heading, my lord.
The spurious liquor, from where it is
Detailed-
coming, whether you have any data saying that like that liquor that has been, I mean, coming from Arunachal, you have seized those and those are, I mean, while
Yes.
those are being sold openly.
Yes, yes.
Then you have seized it.
My lord, can
Where
you
is
see
the
the
data?
heading?
Where is
Details
the
of,
data?
my lord, can you see the heading?
Hmm.
Detailed seizure report of liquor not meant for sale in Assam.
Correct, from where it is coming?
Throughout the state, my
From,
lord.
how do,
From
how
throughout
do
the
you know
state.
that like from the Arunachal Pradesh it is coming? It can come from Meghalaya
Yes,
also?
yes, yes.
Huh?
Both
How do
sides.
you know?
That's why we are saying, well, we have not, my lord, stopped from Arunachal only. We have stopped all interstate trade, my lord, from using the land of Assam, my lord, roads of Assam. These are data, my lord. This is quite alarming, my lord. 37,000 liters illegal liquor meant for other state, we're selling in Assam. And my lord, on top of it,
You have issued an order earlier also, where this order was on 5320, no, 53.
Page number of the earlier order of the election commission.
No, there's another order that has been passed on. 17/2/2026.
My lord.
one given.
That
So
is election commission-
17/2/2026 is already there.
Election commission of India, madam.
Hmm.
Yes, well, that is already
District
there.
monitoring and
That is still there. This is from your office only.
Yes.
That in spite of that, like after issuing this letter, very recently, last month,
Yes.
as far as transit is concerned, and suddenly you banned it.
may I submit 4 or 5 points if you lost.
So let him complete. Mr.
No, no, no.
Goswami, have you completed?
My lord, just one moment. Oh, pardon. Like this, एक minute. So my submissions are basically, firstly, my lord, nobody has an absolute right in fundamental right in trade of liquor, my lord. This transportation is also a part of the trade. Secondly, my lord, we have, my lord, issued this order according to the directions issued by of Election Commission of India during the video conference, my lord. Thirdly, my lord,
But the election commission is saying that like there is no instruction.
No. they have not given any instruction in writing. In a video conference, my lord, we have been asked to pass this order.
Then it should have been written order. You should have asked for a written order. Now, how can I like, I mean, see, this is a big issue. This is interstate commerce. Interstate commerce has been stopped.
No, not interstate
The
commerce, but
commerce-
interstate commerce of liquor, my lord.
Liquor,
Which is a,
correct. It's a
which is
liquor. Liquor you can prohibit. There you have a right to prohibit. You have a right to restrict. But there has to be a backing. Now, only on a video conference something has been said and you have issued this order. I mean, if there is any kind of instructions, written instruction has been given by the election commission, know that this has to be stopped.
Then, my lord,
I mean,
let
have they come up? Have they come up with anything?
Then, my lord,
Have they modified their model code of conduct? He's
Let-
saying no.
In that case, my lord, let the election commission reply, my lord, that whether they have asked
But
to
that,
issue this order or not.
that is why I have asked, I mean, before you only I have asked him whether they have any kind of that.
They have specifically instructed us, that's why we
instructions.
have issued this. And this alarming data, plus, my lord, free and fair election. Only 4 days waiting period for the petitioner, my lord. On 9th, it will be withdrawn.
No, I mean, if the order is bad, then it is bad for 1 day also.
My lord, my lord,
It
kindly
can't be,
appreciate one
it
thing.
can't be for 2
There are
days or 3
judgments, my
days.
lord, to indicate that in under the Excise Act, my lord, any executive order has the full strength of a law.
Mm.
There are judgment to that effect also, my lord.
Mm.
This is not a trade in, my lord. This is not a commerce. This is a race extra commercial.
Correct, that understood.
Business in crime.
Mm.
So they cannot, as my lord, boldly say that this is bad. They don't have any fundamental right, my lord, which is applicable to 301 also. That's why I'm saying, well, another 4 or 5 days. So if we balance, my lord, the interest of a free and fair election and, my lord, the private interest of the petitioner waiting for 5 days, nothing else, my lord. Only one petitioner has come, my lord.
One is enough.
Maybe one is enough. I'm saying that people are not so agreed because 5 days they can wait.
I'm genuine.
We have to make a balance, my lord. My lord, kindly see the public interest. Let's complete.
I'm genuine.
Let me complete.
Yes, yes. yes.
Let me complete.
Complete.
What I'm saying, my lord, only 5 days waiting period. It's not an absolute ban. If we balance, my lord, the public interest of having a free and fair election in a democratic country, my lord, and vis-a-vis the private interest of a petitioner to transport liquor, then the interest of having a free and fair election is paramount, my lord. And secondly, my lord, you also see, there are this data, my lord. These are all liquors meant for other states, transported through Assam. I can give the details, my lord. All seizure list, all the details I can provide. So if we make a comparison, my lord, of petitioner's right, whether it is fundamental or not, interest of a free, fair election, my lord will also appreciate one thing. There is nothing malicious, my lord. We have not targeted somebody. There is no discriminatory action, my lord. We have done it to have a free and fair election.
You have, see, I mean, you are stopping transit from your neighboring states.
Yes.
That's a big issue.
For the time being, my lord.
That's a big issue.
For the
And-
time
and-
being.
And that too on account of your failure. Your failure means you could not stop, selling
We are stopping,
spurious
my lord.
liquors.
We are stopping. but-
Spurious liquors. Now, how they are entering into Assam? Why you have not properly checked? Why
we are
proper
taking, but that's
mechanism
a-
is
my
not
lord,
there?
This vigilance, this checking is a continuous.
So this is your failure, and you to hide your failure, you totally stopping it.
Not hide, my lord. To, my lord, have a free and fair election, my lord. Free and
Free
fair
and fair
election.
election, everybody wishes for that. I mean, everybody is
Yes.
wishes for that.
For that, my lord,
But
we are.
for that, I mean,
For that, my lord, we kindly appreciate. For that, we have imposed a restriction on sale of liquor, my lord, not sale of rice, not sale of mustard oil. These are not essential commodities, my lord. They can wait for 5 days.
No, this is not for sale also, Mr. This is for transit. I mean,
Transit, they will use the road of Assam.
Transit. I mean, transit, you check, I mean, whatever check and balances you want to keep. You
Because,
do
my
it.
lord, in check and balance, this amount has come out. There may be other liquors already being sold. It is not, any system is not 100% foolproof, my lord. So
No, that's correct. I mean, only because of that, your transit, you're stopping. And
transit, my lord, in the name of transit, most of them are selling liquor in the state of Assam, my lord. This is the quantity, my lord, 37,000 liters. We have seized in last 15 days, my lord. That is why, my lord, to make it.
I mean, you have given some figures, but like, I mean, how can this be relied on? How can this be relied on? And how can you say that like, this has only come from Arunachal Pradesh?
Well, it's
How
not
can
from
this-
Arunachal Pradesh. This, there, we are not, my lord. My lord will kindly see the order impugned, my lord.
No, that I have seen that all the states.
All states, my lord.
All the states.
Petitioner is bringing in from Arunachal Pradesh. There are others who are bringing in from Meghalaya. This data is from for the entire state of Assam. And my lord, this has been furnished to me by the Commissioner of Excise.
Okay, let's hear him then. I mean, that's all, Mr. Goswami.
My learned friend that placed the judgment before lordship. That says this is a very bad liquor, very dangerous. But not for Assam. They say that state can restrict, can stop.
No, Supreme Court has said not.
I'm saying, Supreme Court, I'm saying. Supreme Court has they said that the state has the power to stop. If it has to stop, then it has to stop for Assam also. If it is very dangerous, very, very dangerous, I also admit very dangerous. People should not consume. But your lordship may see the judgment at para, my learned friend placed before lordship, my lord. This was para 66.
Hmm.
A, B, C, D, G or C. Madhya Sweetie, খালি এটা side এ। G.
That the judgment of Indian Cement.
No, my learned friend.
Oh, sorry.
My-
Okay, correct. Para?
Para 66, 60.
Yes.
In the first part, they have said the state has power to stop and can do this through the state also. 6, when the state permits trades and business in the portable liquor with or without limitation, the citizen has the right to carry on the trade and business subject to limitations, if any, and the state cannot make discrimination between citizens who are qualified to carry the trade and business. Malak, there is two things are there. The Supreme Court has said. The state has power to stop. They can do it. State can say that we will do it. They can do it. But if the state allows the trade and business in the liquor, then it cannot discriminate. Now, my learned friend, in Assam, somebody is manufacturing, selling, it is not dangerous for human consumption. When it comes from Arunachal Pradesh, then it becomes dangerous. My learned friend is saying that liquor coming from other states are being sold in Assam illegally. My lordship has come across the case in GST. Your lordship has cancelled the bail also. Supari is illegally sold in the state of Assam. Stop the sale of supari. Monitoring means what, my lord? Cash distribution. They are really regularly catching the persons with the cash. That means, does not mean that all transactions will be stopped. What is the meaning of monitoring and the compliance of the act and the rules?
No, they are only ground of, issuing this order. It seems that there are huge sale of spurious liquors coming from other states.
My lord,
They want to stop that.
my lord, the question is that, my lord, then the rules permit that with this from permissions, transit passage and all those things. Now, my learned friend said that I am coming before your lordship. I give an undertaking without the transit passage, whatever liquor will come, it will go to the state of Assam, it will not be sold. Can, if somebody else is bringing, I be punished? My learned friend correctly said, so many people have not come. One person has come. I am a genuine person, I will come. Can my business be stopped? If I don't follow the rules, I don't do anything. If I found that, my lord, that I am doing something, my lord, illegally in the state of Assam, your lordship may observe it. But your lordship they cannot stop my business. My vehicles are lying with the transit passage they are standing in the check post. Can it be said that the elections are over, so will not distribute? Blankets are being distributed in the state during the election process. You stop the blankets coming from outside the state? They are not available in the state of Assam. The liquor is not available in the state of Assam. Can my learned friends say that the liquors are not sold, purchased illegally in the state of Assam and sold and distributed? Wine shops, they are all coming from outside. The Assam dealers and manufacturers, they are all, number one, they are not doing anything. How such an order, my lord, on the basis of Egypt? And my learned friend said the section of the 135, it nowhere says of any restriction. It says only for 2 days. That is a polling day. That in the year, number of days are there where the dry day are there.
No, now he's saying it is till 9th.
It may be till 7th, it may be till 6th. If it has no legal backing for 1 day also, why? As your lordship in the bail, he says, when it is illegal, one cannot say that we 5 days. Even for 1 hour also, detention is illegal. Will your lordship put a seal on the order on the ground that the 9th till 9 they will do it? That means to permit it in the illegality?
Yes,
how-
yes. Yes, I mean, Mr. Goswami, I'm not convinced that this order can be passed.
Plus one judgment. One.
Yes.
It will be open. But before that, my lord, the argument that has been made that the traders in Assam are being allowed
No,
to
that's,
sell.
those things are, I mean,
Well, there-
leave those
my
things
learned
apart.
senior is
I
free to-
am only on the thing that like whether you have a legal backing to do it, and you have shown me the case laws, and you have shown me, I mean, these things that. Yes,
Paragraph 18, my lord. The next important contention
one,
was that.
one second.
My lord,
Para 18,
1979 4 SCC,
para
230,
18.
para 18 and 19.
Yes.
My lord.
Mr. Goswami, you said that under the excise policy, that any executive
Yes,
order
there is
has
a
a,
judgment of this court. my lord.
has a
Force of-
statutory value. I mean, can you place that?
Right now, I don't have, my lord. If my lord allows me some time, well, I can find out. Paragraph 18, my lord. The
Yeah.
next important contention was that this imposed unreasonable restrictions on the freedom of interstate trade, commerce, and intercourse guaranteed by Article 301, or the freedom to carry on trade or business guaranteed by Article 19(1)(g), and the restrictions being not in public interest, the enactment is constitutionally invalid. That raises the often repeated facts question whether right to carry on trade or business in liquor is a fundamental right under Article 19(1)(g), and that some considerations would apply for acting under Article 301. This question has cropped up before the court at regular intervals, but it would be sufficient to take note of two decisions to dispose of the contention. In Harsankar versus Deputy Excise, DUI Excise and Taxation Commissioner, after referring to Crowley versus Christensen, and several cases of this court, it was in terms stated that there is no fundamental right to do trade or business in intoxicants. The state, under its regulatory power, has right to prohibit absolutely every form of activity in relation to intoxicants. Its manufacture, storage, export, import, sale, and possession. In all their manifestations, these rights are vested in the state, and indeed, without such vesting, there can be no effective regulation of various forms of activity in relation to intoxicants. In reaching this conclusion, the court took note of an important observation made in the state of Bombay versus RDM so-and-so, which may be extracted as under. We find it difficult to persuade ourselves that gambling was ever intended to form any part of this ancient country's trade, commerce, or intercourse to be declared as free under Article 301. It is not our purpose, nor it is necessary for us in deciding this case to attempt an exhaustive definition of the word trade, business, or intercourse. We are, however, clearly of opinion that whatever else may or may not be regarded as falling within the meaning of these words, gambling cannot certainly be taken as one of them. We are convinced and satisfied that the real purpose of Article 19(1)(g) and 301 could not possibly have been to guarantee or declare the freedom of gambling activities from their very nature, and in essence are extra commercial, although the external forms in essence are extra commercial. Although the external forms, formalities, and instruments of trade may be employed, and they are not protected by under Article 19(1)(g) and 301 of our Constitution. After extracting these observations, this court observed in Harsankar case that the reasons mentioned by Das CJ for holding that there can be no fundamental right to do trade or business in an activity like gambling apply with equal force to the alleged right to trade in liquor, and those reasons may not be brushed aside by restricting them to gambling operations. Recently, in P.P. Kaushal versus Union of India, after an exhaustive review of all previous decisions, this conclusion was affirmed that there is no fundamental right to trade or business in noxious drinks, which includes liquor. If there is no fundamental, it is very relevant, my lord. If there is no fundamental right to carry on trade or business in liquor, there is no question of its abridgment by any restrictions which can be styled as unreasonable. In fact, as stated in Harshankar case, the state under its regulatory power has a right to control or even to prohibit absolutely every form of activity in relation to intoxicants apart from anything else. Its import too. This power of control is question of society's right to self-protection, and it rests upon the right of the state to act for the health, moral, and welfare of the people. Liquor traffic is a source of pauperism and crime. In this background, it is now too late in the day to entertain an argument that imposition of tax on the import of liquor, which serves the double purpose of restraining so and so, it is on the question of imposition of tax, my lord. So what I was on, my lord, the argument that has been made that liquor is being sold in Assam, but others are not being allowed to do. Well, these two categories of people are different, my lord. Somebody importing liquor, transporting liquor through the state of Assam to other state, and somebody manufacturing and selling liquor in the state of Assam are two different classes of people, my lord. So there cannot be a question of discrimination among unequals, my lord. Had they been equal, they are not equals. Had they been equal, my lord, the question of discrimination could have come. It's not a question of discrimination because, my lord, it's a general ban for all the states transporting liquor through the state of Assam to other states. It's not targeted to owners or not targeted to petitioner. The question of discrimination or unreasonableness does not arise, my lord. And my lord, Assam Excise Act, Section 8, my lord. Section 8, my lord. Rulemaking.
Yes.
Restriction on import, firstly, my lord. No intoxicant shall be imported unless the state of Assam has given permission either general or special or for its import. Such condition, if any, as the state government may impose, have been satisfied, and the duty, if any, payable under Chapter 5 has been paid or a bond has been executed for the payment thereof. Restrictions on import and transport. No intoxicant shall be imported or transported unless duty, if any, payable under so and so has been paid or a bond has been executed for the payment thereof. Prohibition of import, export, transport. The state of government may, by notification, prohibit the import or export of any intoxicant into and from the territories to which this act applies, or any part thereof, or prohibit transport of any intoxicant. Then, my lord, there is a rule-making power also. So, my lord, this power is ingrained in the act, my lord. It's not that we are without any authority. My lord, excise is a power vested with the state, basically to regulate, my lord. Since the state also wants revenue, my lord, it is being sold. It is state is selling it. But, my lord, excise itself means, my lord, it's a restricted trade, my lord.
Yes, yes.
It's not that, my lord, we don't have any power. If we have power to absolutely ban, my lord, any liquor activity, sale or production or transport, then definitely, my lord, it is ingrained in the act to, my lord, restrict for 5 to 6 days or 10 days. That too, my lord, will see the importance is, my lord, free and fair election, my lord. This type of liquor, if, my lord, comes into state of Assam, my lord, it may impact the election, free and fair. So in a democratic country, my lord, election is of paramount importance, my lord. Vis-a-vis the, my lord, private rights that might have been, my lord, infringed for the time being of the petitioner, my lord. So that larger aspect, my lord, may kindly consider.
So democracy has gone into, I mean, I mean, reel going on. I mean, what Plato said in 2,400 years back, he said that democracy is basically run by the people who doesn't have wisdom. So democracy is bad.
Our society, our political system, these are dynamic system. It's growing, my lord. 100 years back, we are under some other country, my lord. Now we are independent. Maybe some time more will be required. But still, my lord, we all are trying to have a democratic country, my lord.
That's in a different context already.
One of the first 4 lines of the judgment which my learned friend placed before.
First 4 lines of
the judgment which my learned friend placed now.
Yes.
In fact, I don't have the copy, so the first 4 lines. Therefrom, we started reading the paragraph 18.
Paragraph 18, sir.
Paragraph 18, no?
Yeah, first 4 lines of
Paragraph 18, Milo.
paragraph 18. Yes. Next important contention.
My lord. ये आपने position हो?
First, 18 and 19.
Where 19 also may similar.
Yes.
In so and so, third line, Lord, if there is no fundamental right to carry on the trade of business or liquor, there is no question of imprisonment by any restriction which can be styled as unreasonable. In fact, as stated in so and so, the state under its regulatory power has a right to control or even prohibit absolutely every form of activity in relation to execution apart from anything else import too. The power of controlling question society right to self protection and rest upon the right to state to act in the health, moral, and welfare of the people. Now, Milord, the ground is that for the health, welfare, etc. of the people of the state, the state can restrict.
The state can prohibit also.
Prohibit also. But a question I am asking myself, Milord, that the health and the safety of the people, all the concern about the state people, can only be from the liquor which is coming from outside, going to outside, not from the liquor in the state. Well, these judgments, both the judgments are on the ground that since the liquor is harmful for the people, and as such, keeping in the concern of the state people, they can restrict. Otherwise, Miller, what will happen? Your Lordship, just imagine, Miller. The state can, the 301, and what was the region of 301, Miller? The 9 judges bench, Miller, in the, when the anti-tax matter was dealt with. The region of 301, what is the region? Earlier, Miller, the princely states were there. One state said that I will not allow the other states to come, goods to come in. The third state said that I will not send my goods to outside the state, allow district. Now, that resulted in a very difficult position. That's why 301 was incorporated, that the movement inside all the countries should be free. Now, if one state restricts the movement of the goods from other state, even don't allow it to pass through, then, Miller, what will happen? If I have got, Miller, the goods, Miller, the goods are there. I say that I will not allow the other goods either to pass through or to come to the state. Your Lordship has come through so many judgments. The restrictions on the interstate movement of it. If it is restricted, the state said that we will not allow the consumption of liquor. Absolutely stop it. They can do it. But if they allow it, then they cannot say that we will not pass through and this. Now they are saying again and again, election. You'll also have seen the notification of the Election Commission of India at page 120 of 2026. The latest notification before the elections, page 82. Judgment is not. The Election Commission of India is very much aware that what they can do, what they cannot do. Restrictions. 82, you lost me.
Yes, yes. Now that I've seen.
With the Enforcement Election Commission issued direction to Chief Secretary and so, the 26 February 26. Huh? Page 128. Page 128. The restriction is area 1. Page 128, my lord. My lord. Second, the Election Commission, this election so on the companion instructed the election expenditure monitoring and specifically directed is to deploy officials on the border checkposts to prevent the cross-border liquor movement during the elections. Now, therefore, in exercise of the powers under section so-and-so of the Assam Excise Rule, so-and-so as amended, the undersigned is pleased to issue the following further restrictions on the proper implementation and enforcement of the provisions related to the transit of the liquor through the state of Assam for so-and-so. You check, you do whatever you like.
No, that is what the question is, Mr. Goswami. See, you have issued this as per ECI. Only in the last month. After the following that election commission's detailed this thing. Now, after some time only you have changed this. And you have taken the name of the election commission also.
Yes,
This time also.
yes.
But you have not, I mean, this is fine. I mean, this is, I mean, okay, this is as per the guidelines or whatever the model code of conduct is there, you have issued this. And you have not stated also, I mean, you have not mentioned anything about this also. That this has been in superstition of that, you haven't said anything else.
Vote will prevail, my lord. Vote will remain in.
But can the Election Commission of India also go against the Constitution?
No, that is a different matter. That has to be.
I'm saying.
For that, my lord,
That is why
Election Commission reply, my
I
lord.
was asking Election Commission.
I'm asking, Election Commission of India also for conducting the elections, free and fair elections. And for that, the proper directions have been given. I'm not saying that you don't monitor. You fulfill all the norms and regulations, whatever are there. Check that the liquor is not coming to the state of Assam. It passes through. Whatever provisions are there, you strictly imply. But you cannot totally say that, and I will also further submit, my lord, your lordship may not give a general order. Because my London friend said, my lord, so many people have come. I am saying, giving undertaking, that I am not doing, other persons are being restricted. Unless until they come and give undertaking for lordship, that he will follow the full rules and regulations monitoring, and not a single liter of the liquor will be sold in the state of Assam. It will pass through.
Well, this is an order in RAM, my lord. If it is.
No, he's saying that he's going to give an undertaking to that effect. You are concerned with that only. You are concerned with
people who are there. They are coming.
Yeah, you are saying that like because you are concerned with the illegal selling of the liquor which is coming from there. He's saying that he will give an undertaking.
Not a single liter.
He's saying that he's before this court. I mean, he's leaving aside other arguments. He's saying that he will give an undertaking that nothing will be done in this.
Full compliance of the rules and regulations, and the entire liquor which is meant for the outside the state will only pass through. Not a single liter will be sold in the state of Assam. So their interest will say. You know, my London friend correctly said there's so many people have come. Are they not coming?
No, that's a genuine concern he has raised.
That's why they may be the persons whose liquor has been seized. Who knows? But since I have come before lordship, I'm giving an undertaking. You know, in my humble submission, my vehicles cannot remain on the road, and that it must pass.
That, my lord, may allow me 10 minutes. I will just have a discussion with my clients.
I mean, see, Mr. Saraf, you will also realize that to passing an order, this court will also take some time. The provisions has to be seen, and all these things has to be seen. But if you are giving an undertaking, that is a different issue altogether.
Well, I'm not saying I don't intend to bring the liquor and sell in the state of Assam. That is not my purpose.
No. The thing is that like, if there is an order has to be passed, staying this impugned order, then all the things has to come to a statute.
I am saying that.
But now since you are saying
stay in respect of the petitioner only.
So since you are now saying that you will give an undertaking, then it's a different thing altogether.
I am saying that your lordship will stay the order in respect of the petitioner and the undertaking your lordship.
Then by Monday it will be flooded.
That what will remain, my lord?
Then, my lord, if I give this concession today, regarding their interim prayer, if that order is passed, my lord, by Monday, my lord, this court will be flooded with another 100 cases, my lord. And I will be not in a position to resist.
My lord, if Monday something is coming,
then I will not be in a position to resist, my lord, because I have given concession, my lord.
My lord, if they seize something illegally, this is your lordship's order. Thereafter, any liquor of the petitioner is seized, it will have a far-reaching consequences. Any person before your lordship, coming before lordship and giving an undertaking, is not only the authority. It is undertaking given to the court. And thereafter, any liquor which is brought from the state of Arunachal Pradesh by the petitioner is found in the state, that will be a violation of the undertaking given by the court and have a far-reaching implications.
My lord, I think, my lord, we can also explore one possibility, my lord. Let election commission reply, my lord, whether this was issued as per their instruction. If this is not required by election commission, my lord, we will withdraw.
My lord, my submission will be there that today is Thursday, today is 3rd. My vehicles are standing there, transit passes are.
The
going
order
to
was issued
expedite.
in 24, my lord.
I
24.
understand, 24th, how much expedite we do something? Something we have to expedite, we file it, we mention before lordship and we are coming. Now, my lord, can my transit passage expire and everything after this, all these undertakings, will the lordship will not protect me? I am totally on your lordship. I don't say anything more, my lord. Otherwise, my lord.
You take some instruction. Yeah, you come back in for 10 minutes.
10
And Mr. Ali also. No, no.
Election commission is done, I mean, because of them we have issued.
For the instruction, I've got this SOP also, as of now, I don't have the written instruction as regards the.
But you have stated that like there was no instruction given. That's what you have stated, submitted.
And since this is on the basis of the Election Commission of India, then if the Election Commission of India, the other state has no concern.
Okay, so 10 minutes after will come, my lord. Order from
Because the state has no power, it is only on the basis of Election Commission. So if the Election Commission does not have, has not issued any notification, otherwise the notification of the February was there.
No, that is why, I mean, that there is no document showing that
Then-
they have given any instructions.
Then, my lord, how it can be on the,
So that's what, I mean, now he is saying that he doesn't have any instruction on
and
that.
on the verbal basis, such instruction cannot be issued.
So you, if you also get it, I mean, 10 minutes, 15 minutes, Mr. Sarab, then we'll take a call on this.
My lord.
Take a call. Mr. Goswami, you take instruction. He is giving us some undertaking, huh? I mean, your concern, I mean, probably be protected if he gives
The
an
lordship will
undertaking.
quote my
Perhaps, my lord, my client would also agree, I will also agree that if. an
Only
order
thing
is-
is that I mean,
Instead
you're
of touching the order, an order is passed, the petitioner's consignment will be allowed to.
correct. He's
Instead of
concerned,
passing an interim order.
and he is ready to give an undertaking
Yes.
also, saying that like, if
That-
My lord, I'm not interested in getting the order stayed because.
Because the submission was made,
Because-
the order should be stayed as regards the petitioner is concerned. Instead of that, my lord, if we
Yeah.
allow them.
The purpose was that, Lord, if your lordship allows this way, that way, I have no difficulty. I am not interested in that the order should be
only
stayed.
thing is that, I mean,
Petitioner's
on
consignment.
on the basis of a undertaking of the senior counsel, that like his client will not do this, then his consignment should be allowed to pass through.
As to, as
That
per
perhaps
the,
maybe-
strictly as per the provisions of the act and the rule instructions.
As per the instruction that was issued on 26th of February,
Yes,
26th of February, that is.
I'll follow entirely.
10 to
everything.
15 minutes, I'll come back now. To be order for.
I shall be waiting, my lord.
10, 15 minutes.
Fine.
Asking the guy, washroom. I'll just rise for 5 minutes and come back. Yes, yes.
PWD is furnished the instructions. Lordship, we are expecting the vetted copy of the affidavit by today evening. 1 week may be allowed, Lordship.
You are appearing for whom?
On behalf of Mr. P. Nayak for PWD.
Uh, uh, MSL Devi for Learned Counsel is present. MS, your name?
A. Borthakur.
A. Borthakur, the Learned Counsel, appearing on behalf of Mr. P. Nayak, the Learned Counsel, appearing for PWD. Submits that she requires 1 week time to file an affidavit in the instant. You are appearing for respondent number who? PWD respondent number? An affidavit has already been filed.
4 and 5. 4 and 5, Lordship. The 2 also.
Oh, okay. Respondent number 2,
2,
4 and 5. Respondent 2, 4 and 5, whatever submits that she requires not 1 week time to file an affidavit in the instant case. There is error, let the matter be fixed after the beautification.
Lordship is fixed here.
After the beautification,
Obliged.
let them file.
But I'm your lordship, remembering my lord that I told my lord that this case, my lord, your lordship will find I have come earlier, your lordship gathered on the ground of the 47, 48 mile, basically. Now we have come at your lordships to see by the by basic cases that by the co-accused is only on that mile over here. And your lordship kindly see my arrest is next day, my lord, not on the particular day, my lord. On that day, my lord, I was there in the house.
They got the benefit only because, I mean, there was.
That's
procedural
what
lapses.
others got benefit.
Yeah, in this case, CD was called
But-
for. Today we have not received a CD, Lordship. They have sent us a WT message praying for a short.
But a CD, what CD will do in this case?
Because
Because basically they are arguing that a co-accused has been. given.
Yes.
what is the earlier rejected matter, Lordship? What is there now? What is there, Lordship?
So I'm
Because
not
it is-
inclined to give any relief.
This question, my lord, your lordship, 2 children, my lord, they made 4 years, 9 years, my lord. And others get benefit, no doubt, technically others they got it. But admittedly, they say the next day, my lord, next day. Neither.
Correct, I mean, huge quantity,
He was not at all, my.
huge
But
quantity.
husband's wife, was that,
No, from the house, you are perfectly aware of everything what is going on.
my wife, how much role she, my lord, was having in that here, my lord.
No, I'm not inclined, Mr. Chaudhary, I'm sorry. I'll reject this. If you want to withdraw, you can withdraw it, otherwise I'll reject this. I am not convinced, Mr. Chaudhary. I have gone through this, I know about the whole, I know about the whole case, but this is
My
something.
true statement, my lord, your lordship, my lord. This is my case, my lord.
I mean,
So for the second time it's concerned.
that is, I mean, that I have seen.
No, my lord,
Otherwise-
contrary, of course, my lord, that I am not on that. I am, my lord, was saying that, my lord, on that basis of this on 15, next day she was arrested, my lord.
Correct,
Next
I mean,
day.
correct, I
She
mean,
was already in the house, my lord.
correct, I mean, she
And
was,
it was
she was in
another
the-
floor, my lord, not her floor also, my lord.
whether those people have been arrested? Those main
The
accused,
main accused.
they're still absconding.
Oh, their petition is pending here, my lord. Maybe it's pending here.
Mr. Chaudhary, it will
My
be.
lord, I understand, my lord, but your lordship, on that basis, my lord, co-accused statement, that is the only thing.
You
That's-
give, please submit,
Yes.
give me this.
If it is some other person, then co-accused statements may take, that may be a ground, but it is from their house, he, the wife of the main accused, from their own house, it has been
That's the
recovered,
right part of that.
everything, lordship.
They are in the first floor and that is second floor.
All persons are caught red-handed, while other persons are caught red-handed, while
Yes, yes, other
intoxicating in small quantity, lordship, everything is there, lordship.
That person was arrested, caught, but on the same day, same place, same time. From another floor also, my lord. It is not the joint family, no, they are not joint family also. my lord.
This co-accused case will not be relevant for this case.
But the relevance, my lord, but actually law applies equally to the same judgment. But admittedly, my lord, your lordship will decide whatever, my lord, I am not on that one. Question is, my lord, on the day when the occurrence took place. Second floor, we have given statement, my lord, category statement that we did different separately, my lord. We signed the first floor, my lord, and that occurrence took place on the second floor. My brother, my husband's
You
brother,
tell your husband to surrender, we'll allow your case.
my lord. But your lordship know the role of the wife of the Indian society, how much the village people, I am not saying that they are very educated.
Mr. Chaudhary,
How much role they
Mr.
have
Chaudhary,
whether they have any control over husband, my lord.
I could have understood. I mean, had it been a different circumstance, but here the circumstances are
I am sure, I am absolutely with your
pretty,
lordship.
pretty difficult.
I am
I mean,
only saying, my lord, this law whether applies in my case or not, my lord. Yes, it was my lord, recovered from the other person, not from her, my lord. On that basis, I am just praying your lordship, my lord.
I'll consider this.
You must kindly see this, my lord.
I'll consider your submissions.
And other already on that other ground, but ultimately they were the found, my lord, with their possession, they have been released, my lord.
That's the technique.
The law, my lord, they have given. But my one look wants to 2 my lord, 4 years child, my lord, and 8 years child. And one is very seriously.
I'll take those things, I'll consider this, but
I
I'm not
think
very
your
inclined, I'm not very inclined, but like I'll go through this.
Maybe your lordship, it may
I'll
change
go
your lordship
through-
mind, my lord.
I'll go through this again because it may change. We don't know where. I mean, if this. court
Only
is
thing is,
finished-
my lord, because she was neither in possession nor that is the next day she was arrested, man. Only on that.
I'll look into it.
But- Allah.
It was a prosecuting officer, chamber.
This case, my your lordship, kind of see your lordship idea, order, my lord. Total, my lord, 129 kg, my lord, American arts, my lord. And it was stated that, my lord, from the second chamber. I am the owner of the vehicle. I have given on the rent. Idea, my lord, this rent, this agreement was not given, my lord, idea. Now I have given, and now you will kindly see second chamber, my lord, it cannot be 129 kg, my lord, bag is 4,000. 4,385 kg, my lord. Is it second chamber in the, my lord, it cannot be in that second chamber, my lord. And I do not have any idea, my lord.
Mr. Parasar, what do you have to say about this?
See, here in this case, Lordship, that materials has been recovered from that secret chamber as per the CDA.
Secret chamber, we have considered this argument
apart
earlier
from that
also, but only thing is that,
Apart from that, Lordship, that his phone number, the CDR was called for, that that is yet to be received, and at the same time, that material that has been recovered from that truck, Lordship, those are sent for that for food analysis report. That is yet to be received, Lordship. More particularly that CDR, because Lordship, one person, that person who has been arrested, he has admitted, he has stated, Lordship,
no,
that
he is
from
not,
this number.
I think he is not denying about the phone calls or whatever,
Yes.
because the vehicle is his.
Yes. And agreement is page 15.
Vehicle is his. The only thing is that, I mean, we'll have to see, I mean, his involvement, right? His involvement, and he's saying that like, he has an agreement. I mean, that agreement, I've seen that like it was prior to the incident, obviously prior to the incident. And another thing is that, that
4,000 kg
secret,
is not a
secret
secret
chamber, the secret chamber for 4,385 kg.
So that I will take instruction, Lordship, like on Monday, Lordship, I will take instruction, Lordship, because Lordship,
I think, this, I mean, this is little bit improbable.
quantity is huge, Lordship. If it is Burmese superior, quantity is huge, quantity, Lordship. So,
I don't think the superior 4,800 quantity from
how
secret
it is,
chamber.
Lordship, that is true, Lordship. How it is a secret chamber, how it can come. That I will take instruction from the IO, Lordship. Lordship, we can take up on Monday, Lordship. Only one.
So let him take the instructions.
Then Tuesday.
Lordship.
Okay, we'll fix it on Tuesday.
Second
Take
country,
instruct-
my lord.
Yeah, you take your instructions.
On that.
Tuesday 7, my lord.
Okay. I heard Mr. H.R. Chaudhary, Learned Counsel for the accused applicant, also heard Mr. K.K. Parasar, recent PP for the state. Mr. Parasar submits that he will take instruction.
Yes, Lordship.
Instruction in the case as far as recovery of the alleged arcane nuts from the secret chamber of the truck owned by the accused applicant. Full stop. Let material fixed on 7.
7.
May I please, my lord? My lord, I'm praying for PRS bail, my lord. That, my lord, FIR is page 16, my lord. Page 16 FIR.
FIR.
FIR, my lord. With all respect, my lord, may I read this FIR, my lord?
You are appearing for whom? One person only?
Yes, only one person, lord.
Yes.
May I read this FIR? I have honor to report that on so-and-so date at that about so-and-so time, an information was received by officer in Sangsari police station from one Majibur Rahman to the effect that one scooty was detained by the local public on the road near Sangsari railway station with a bag suspected to contain narcotic substance. Next parameter. According as General Diary, entry number so-and-so dated so-and-so was made. Thereafter, the officer in Sangsari PS constitute to me in their proceed and a place of occurrence, and accordingly, I, along with the police party, proceeded to spot along with the NDPS kit bearing ready to search and seizure. Next parameter. The police party considered so-and-so number. Next parameter, Lordship. The prior to proceeding, the verbal intimation was given by Deputy SP headquarters of the authorization letter to search and seizure was obtained through the proportional. Thereafter, the police party left the police station in a Golf Bolero vehicle bearing registration number so-and-so driven by SS Safiqul Ali and reached the Changsari near railway station at about so-and-so time. At the spot, one Activa scooty, the bearing registration number so-and-so was found. I have searched the trace out of the rider of the said scooty. However, I am unable to find out him. After receiving of the authorization from Deputy SP headquarters, a search of conducted at about so-and-so time in presence of independent witnesses, namely Shintu Lahkar, age about so-and-so, son of so-and-so, residence of so-and-so. District so-and-so.
Correct. Then.
And next paragraph, Lordship, that during search, one blue and yellow color bag was found.
This was recovered, correct. Then.
Yes. Then independent witness Hasem Ali so-and-so resident so-and-so next parallel.
Correct. The seizure was made then.
Yes. During the search on the blue yellow color bag to found was scooty. On opening the bag, suspected ganja was recovered. During the statement of the witnesses, they revealed
Now that I have gone through. Yes.
yes, Lordship.
Hmm.
That as per FIR, Lordship, the packaging of the contraband.
So the person was not found in the scooty. That is
Yes,
the
correct.
thing.
Yes,
Correct.
and not
Then
conscious possessions of
Hmm.
this present petitioner and involving Lordship. This present petitioner is owner of the offending vehicle, that is the scooty. Otherwise, this present petitioner is no.
So who was riding the petition? We were
Yes,
riding.
Lordship, I mentioned this. Yes, Lordship. Lordship, page 5, paragraph 8, Lordship. May I read this paragraph? This is genuinely and bona fide statement, this present petitioner, Lordship. That the present petitioner most respectfully submits the true and actual fact of the case.
Okay, I got it.
Yes, Lordship.
What is there in the case diary?
Yeah, Lordship, I have Lordship, that 4 kg and something that has been recovered, and the witnesses has stated, Lordship, that those has been it was kept at the footstep of that scooty, Lordship, but nobody was there, Lordship. But it was his scooty belongs to him, Lordship.
So directly implicating him, there is no material.
Directly not there, Lordship, but the scooty was there. His intermediate quantity, no? Quantity intermediate quantity. Okay.
Let him go. I mean, there is no implication, direct implication. He was not found, and he has stated that his scooty has been taken by somebody else.
There is no any
If
evidence. I
some
haven't found
material,
any
if some
evidence, Lordship.
materials comes after the investigation, you can always come back. After the investigation, if there is some material, then of course you can always come back. And heard Mr. A. Datta, the learned counsel, appearing for the accused applicant. Also heard Mr. P.S. Lockhart, the learned APP for the state. Then he writes the decision application under section 482 of BNSS to 2023 for granting pre-arrest bail to the accused applicant, namely namely Mohidul Islam, in connection with Changsari PS case number 21/2026 under sections 20 in bracket small b bracket small 2 bracket capital B of NDPS Act. Full stop. The gist of the facts in the instant case is that an FIR was lodged on 3/2/2026 alleging inter alia that the OC received an information from one Mujibur Rahman to the effect that an Activa scooty had been detained by local police near Changsari Railway Police Station Road, along with a bag suspected to contain narcotic substances. On the semicolon, that on receipt of such information, police team went to the place of and on search of the scooty, they found they recovered, no, don't write found, they've recovered 4.443 cases of suspected cannabis. Full stop. The learned counsel appearing for the accused applicant submits that that admittedly the concerned Activa scooty bearing registration number AS 25A1613 belongs to him. However, he is not involved in any smuggling or any selling or transportation of the aforesaid contraband materials recovered from his scooty. He submits that, in fact, his scooty was taken by one of his friend, namely Akbar Ali, to procure certain medicines, and on good faith he had given his scooty for the aforesaid purpose. Thereafter, he is not aware not aware whether what the aforesaid friend of his has in fact done taking his scooty for the aforesaid purpose. Full stop. He submits that he came to know about the seizure of the aforesaid contraband materials, and therefore is in serious apprehension that he will be arrested by police in connection with the aforesaid recovery of contraband materials. The learned counsel submits that since he is neither implicated in the instant case, nor he is consciously involved in transportation or selling of any of the contraband materials, nor any contraband materials have been seized from him, he should be allowed to go on the arrest bail. He further submits that he is willing to cooperate with the investigation and appear before the investigating authority as and when required. Full stop. On the other hand, the learned APP appearing for the state has produced the case diary which reveals that no person was found to be found in the position of the scooty, and only and due to the ownership of the scooty is in the name of the accused applicant. The accused applicant may have some apprehension. Full stop. As per this court has gone through the case diary and has seen that as per the statement of witnesses also, no person was found to be in possession of the concerned scooty. Full stop. Next, taking into consideration the whole facts of the matter, this court is of the considered opinion that at this stage the accused applicant should be granted the privilege of pre-arrest bail. Accordingly, it is directed that in the event of the arrest of the accused applicant in connection with Changsari Police Station case number 21/2026, he shall be released on bail on furnishing of a bail bond of ₹30,000 with a surety of like nature to the satisfaction of the arresting authority, subject to the following conditions. Number one, that the accused applicant shall appear before the investigating officer within a period of 10 days. Full stop. Next, the accused applicant shall cooperate with the investigation and appear before the investigating authority as and when required. Next, the accused applicant shall not try to influence any that clause include shall not try to influence any of the witnesses. Wo clause hai na, wo dal dena. In view of the aforesaid direction, the instant AB application is disposed of as allowed. There is no material
Because it was kept at the footstep of the scooty.
So only because, I mean, that vehicle was.
It is,
If you find some material after the investigation, you are at liberty.
Highly obvious.
34. Well, my instruction is that the suggestion that has come that let them, they say that if they file a representation, well, they will try to consider favorably by Monday. If that is agreeable for a petitioner, then okay, else my lord may pass an order on merit.
My lord, I have not come here with the consent and the reward, which is relaxation. I have come to exercise my constitutional rights.
Then my lord may pass an order on merit.
Your lordship pass an order.
Okay. But there was a good suggestion, Mr.
Yes, I also tried to convey, they're apprehensive that it will be flooded with other claims. I tried to impress them.
And what about you?
As of now, we have not released. Even I have not received instruction as regards the video conferencing also. But we are, as per the earlier the SOP that has been issued to Lordship, as per our instruction, there is very much clear as per our SOP that is. As it is monitoring.
No, in the, I mean, in the earlier stage, you stated that you have submitted that there was no instruction given to them for this.
My specific instruction is that the chief chief election commissioner verbally directed in the video conference.
Yes, I don't have the instruction, Lordship, to submit. Since I don't have written instruction, it will be wrong on my part to give submit.
While passing the order, my lord may kindly take note of these 3 sections, 8, 9, and 10, mostly 10, my lord.
No, 8, 9, and 10 is there for usual cause. I mean, that is there. But in this case, like your specific, this thing is that like you have done it on the instruction of the.
True. Even otherwise, if there had been no instruction, my lord, then also state is empowered. That is my submission under section 10 mostly.
Okay, I'll pass an order then.
Deeply obliged.
Although unusual prayer, my lord. Unusual prayer, although, but if you can, whatever order is there, if you can get today, my lord, that will be.
Today, I don't know. I don't know.
So tomorrow and day after Saturday and Sunday, my lord, is closed. Either your operative person, either way, my lord, whatever order your lordship passes.
And tomorrow you'll get it. Tomorrow you'll get it, but today I'm not very sure.
Either
But
operative.
because there are certain
No, my lord, the
provisions.
operative person, thereafter your lordship may give a regional order, my lord.
We'll see. We'll see.
Your lordship may
I'll try
It
to.
will be an interim order, my lord.
I'll try.
Since it will be an interlocutory order, my lord.
No, what further remain?
Part order will not.
Because I mean, after this thing 9, you're saying that nothing will be there.
Yes.
So nothing remain in the petition.
So I mean, this should be, I mean, whatever order is will be passed, it will be kind of a final order only.
There is nothing to further to my lord after that.
No, I mean, do you think like there will be any purpose of like only passing that interim order then keeping this thing?
Otherwise also, if
No, what do you say? I mean, I'm just
After
asking.
9th, it will be just.
If my lord passes an interim order, there is also one law that says, my lord, in an interim order, final relief cannot be granted. So better it may be.
No, he's asking for this thing also. No, he's asking for two these things. So matter is substantially heard.
My lord, without issuing notice, without affidavits, my lord, passing a final order will also be.
That's why I'm asking you, like, whether if you're agreeable, then we can pass an order, final order. If you're not agreeable, then again, interim order is.
If you also pass an interim order, I know.
You have to pass an interim order then.
As your lordship pleases.
Okay, we'll pass an order.
Deeply.
Right down, I heard Mr. A.K. Saraf, the learned senior counsel. Assisted by Mr. Sharma, the learned counsel, appearing for the petitioners. Also heard Mr. P. Goswami, the learned additional advocate general, appearing for the excise department. Also Mr. A.I. Ali, the learned counsel, appearing for the Election Commission of India.
Although at least that must be recorded that my learned friend said that after 9th it will not be operate. So to stop the other petition.
That I'll record.
That is my submission.
That he has submitted from the very beginning. Only.
My learned friend is also that.
No, he submitted it before starting his argument.
I'm saying that to stop the other people like coming. So at 9th onwards, it is not just other people.
So 9th, you are saying that 9th, it will be operative only till 9th.
Till the date of election.
Other petition, people may not.
Okay, we'll pass on.
Highly obliged.
Okay.
21 orders.
Please, your lordship, lordship, we have filed an additional affidavit, lordship. And also our dusty affidavits has been filed, lordship. We were directed to take steps upon the respondent number 5, lordship. To that.
So you have filed,
We have filed our dusty affidavit to that extent. We have filed our replies to the counter affidavits filed by the respondents, lord. Lordship may fix the matter for final hearing. And lordship, since the matter pertains to eviction, lordship, there is a stay order in our favor, lordship, and we would like to file one application for constituting a for appointment of an commissioner, lordship, for verification of the spot. So, lordship, prior to the
then let the party come, I mean, you have, who is appearing for respondent 5?
lordship, respondent number 4, lordship.
5.
Private 5, lordship. Lordship, when we took the dusty service, lordship, we served a copy to the DC, lordship. However, they at first they accepted the notice, lordship, then they refused to accept the same, lordship. To that extent, we have filed our dusty affidavit, lordship, supported by one affidavit also.
The dusty
Exactly.
affidavit has been filed, serving on whom?
Lordship, in the office of the Deputy Commissioner, lordship. The seal and sign, lordship, may kindly see page number 108, lordship, the notice. Lordship, office of the District Commissioner, they, at first they endorsed their seal, lordship, then they made a cross sign on it, lordship.
So how can it be termed as served now?
Lordship, to that extent, we have filed it, lordship. Now, we are not aware of who is the chairman of the Land Advisory Committee, lordship. We took due steps, lordship, but we are unable
But
to.
they should clarify DC's office.
Lordship, if DC can assist us in this.
DC, you are paying. So, I mean, who is, they are not aware, so as per the direction, they served on the DC. And the DC refused to take it later on. So I mean,
The SLBC or other thing is there. Constitutional Advisory Committee is there. The DC, how can man the land advisory committee is there?
no, the stay has been served as per the direction of the court. Is this an existing body? Land Advisory Committee?
My lord, even to the best of my knowledge, my lord, I am appearing for respondent number 4, my lord. There is no such authority as the Assam Land Advisory Committee. What happens is, my lord, there in the district level, my lord, there is a district level land advisory committee where, my lord, all claims, my lord, for getting allotment of government land.
So maybe they are mistaken.
They have mistaken, perhaps they have mistaken, my lord. So that they should inquire perhaps and then rectify and correct the cause title and thereafter serve, my lord, if at all it is necessary. Or they can themselves come to the court and say that is not necessary, my lord.
Maybe in the district level there is a body, but
However, lordship, since my respectful submission is, lordship, since the matter is being taken care by the DC only, lordship, the chairman is not required, lordship, the respondent number 5. That may be, lordship,
Let
may
him
be
make a
struck,
prayer for
lordship.
striking out the respondent, then, my lord, everything will come in order, my lord, because otherwise everybody is represented, my lord.
Lordship, the pleadings are completed, lordship, may fix a date for final hearing, lordship.
no, that's a service of notice. If you are making a party, then service of notice has to be there.
Lordship, we tried, lordship, and
But there is a non-existing body, they are saying.
then we'll file the due applications for.
You file an IA to strike it off.
Lordship, we'll do that.
File, a non-existing body, then why? What, Mr.
Lordship, HR does.
HR does the learned counsel appearing for the petitioner. he submits that he is going to file an IA to strike off the name of the respondent number,
Five.
respondent number 5. Strike off the name of respondent number 5 as respondent number 5 may not be required for adjudication of the instant matter. Full stop. Prayer is allowed. Let the matter be fixed after the BU vacation. Mr. G. Chaudhary is present for
Respondent number 4, my lord.
respondent number 4. Mr. G. Hazarika for respondent number 1 and Mr. Hendik for Hendik for 2 and 3.
Lordship, the interim order may continue.
Interim order so passed earlier shall continue till the next date of listing. Affidavit not filed.
My lord, as here forest department's role is only to see the origin of stones in a stone crusher, my lord, but the prayer is for closure of a stone crusher. And that has to be, my lord, done by withdrawal of consent to operate, my lord, by
Pollution department.
PCB will have to do it, my lord.
PCB is there. Is anybody appearing PCB?
Initial perhaps even.
Okay, we'll post it somewhere. Nobody is there. None appears for the petition. Huh?
APDCL may not be a necessary party in this.
Oh.
APDCL.
Oh, APDCL also there.
Yes, sir.
Okay, let him come next time.
And one more thing, my lord, as per last order, service was not complete on respondent 9. That is the proprietor of the stone crusher, my lord. So.
Oh, one second. Oh, he hasn't taken steps only.
Yes, ma'am.
Not there, huh? Last year also petitioner was not there. No, the last time he was not well, petitioner's counsel. Okay, we'll pass it over. But it was long time back. 2000, in October 2025. Okay, none appears for the petitioner when the matter was called for. However, Mr. Borthakur, Mr. I. Borthakur is present for respondent number
1, 2, and 3.
1, 2, and 3, and Mr. KP Pathak for respondent number 6 and 7. Mr. Hendik for 8. Let the matter be posted in the month of May.
My pleasure. I am very allowed to withdraw this petition. It become infectious.
Okay, Mr. S. Islam, the learned counsel appearing for the petitioner submits that the matter is infructuous and he should be allowed to withdraw the instant petition, full stop. The matter, the instant petition is dismissed on withdrawal. Take down their names. Mr. Goswami for respondent number 3 and
Miss L. Izung on behalf of Mr. G. Portable.
right, respondent number
1, 2, and 4.
1, 2, and 4. Take down name. Name. Give your name. Give your name.
May it please your lordship. Lordship, the order of the Lawajima court, your lordship, dated 19/3/26, your lordship, suggests that service is complete, your lordship, under all the respondents, your lordship.
Okay, Mr. M.I. Hussain. Hmm?
MDI.
MDI Hussain. MDI Hussain is present for the petitioner. The Loazimo Court report dated 19/3/2026 reveals that service on respondent numbers 1, 2, 3, 4, 5, and 6 has been completed. Let the matter be listed for admission in the usual course.
Budget.
And 26. Lordship, in this case, I'm being led by Mr. Kane, so he's just coming, it may be Passover timing.
Timing, there is no time now.
Lordship, actually what has happened is that there is a, first item is a contempt case. Lordship. The contempt case has been filed with respect to a order of contempt or that has been committed by the contemptors with respect to an interim order, Lordship.
Where is the order?
Lordship, page 70. The starts from page 11.
Yes.
Lordship, may I read the order? Because the facts would be revealed here and the operative function would be, then the operative portion would be in. What has happened, there is a shop. The shop was there. There was the shop between me and the private the contemptors, there was an agreement for the shop. On the southern side, there is the road and there is a space between the two, the road and my shop. On the eastern side is a lane. What had happened is that they illegally gave, and that is my submission, that illegally gave the portion from the road till my shop to some person, wherein that person constructed a kiosk. Against that or that kiosk, it's not a construction, it's a temporary structure. The kiosk was placed in front of my shop. On the left, on the eastern side, again,
In front of your shop or?
My shop. There are pictures, which the pictures will reveal, that I'll show. So once that was done, we wrote to the GMC saying that this is an illegal structure, it needs to be removed. The GMC was not acting upon our representation, so we filed this instant case. When this case was filed, this interim order was passed. In this interim order, it was clearly said that my eastern side and the southern side should be clear. This is what is being reflected in the interim order. That is the facts will be reflected there. So if it comes, page 17, if your worship takes
Yes.
para 17, worship. The respondent number 3 and 4 will ensure the removal of the obstruction on the eastern side and ensuring entry and exit through the southern side within 3 days from today without affecting the kiosk of Muhammad Ali. Muhammad Ali is the supposed.
So the order is to clear the sides, not the kiosk.
Not the kiosk. So the intent of this order is that you clear everything, don't touch the kiosk. The GMC removed the kiosk. So meaning thereby in my respectful submission.
The kiosk is yours or what?
No, it is someone else's. That's why I complained. So the southern side and the eastern side should be clear. That is that is the understanding of this thing. It was clear, and I have given a categorical statement.
No, now what has been done by GMC is that
the kiosk has been removed.
So what is the problem then?
They are not allowing me to, because the respondent number 3 and 4 are the private respondent.
The kiosk has been removed.
Yes.
Eastern side and southern side has been
the specific direction. Respondent number 3
ensure removal of the obstruction
on the eastern side.
Eastern side.
And ensuring entry and exit through the southern side within 3 days from today without affecting the kiosk of Muhammad Ali. Muhammad Alam.
So they have removed the kiosk.
No, they did not remove. The GMC removed the kiosk.
That's what I'm saying.
Yes.
The GMC removed the kiosk.
But the respondent number 3 and 4, they have not allowed me to enter the shop.
Who are 3 and 4? The
respondents can be seen in the order at page 10,
3 is Syed Aminul Alam and 4 is Syed Rahina Alam.
The 3 and 4 are, they are having some shops there.
No, they are the landowners. Lordship, if there are photographs which have been placed, if Lordship comes to the writ petition for a moment, it will clarify the situation. If Lordship comes to the writ petition, page 70.
Which petition?
There is only one writ petition.
6199.
6119. Page 70.
Is
70.
yeah.
So this is the dated, this are all of the particular dates. This is Manjid Hospitality, that is us. This was the shop. The front space that is there, this was there. Now, next page, Lordship, page 72. 70 is the situation on 1510. On 2110, they put a kiosk on the southern side and on the eastern side is the wall. Page 73 of Lordship goes, the clearer picture. My shop is in between that.
Your shop is this Manjit Hospital.
Yes. If page 73 is seen, Lordship, I am in between that enclosure. So I have been given this place. I have been blocked in always.
No, I mean your shop has been blocked.
Yes.
By the kiosk.
By the kiosk and the wall. They removed the wall, but the kiosk was not removed by them. That's why they had not removed the wall. They had the kiosk also was there. We filed.
No, you said the kiosk has been removed.
Yes, after the filing of the writ petition and the interim order. Then Lordship, what happened?
Then now you want that eastern side and southern side should be also removed.
Yes. Now what had happened, Lordship? After the passing of this interim order, we told them that GMC removed the kiosk. In fact, there is a specific statement on the date on which the kiosk was removed, which is, Lordship, I'm traveling, Lordship, to go to the contempt petition again. That is the scenario with respect to the shop before we had filed the writ petition. The writ petition was filed. Then the 18/12/2024-25 order was 24 order was passed, and then we were constrained to file this contempt petition because in the interim order it was specifically mentioned that the southern and the eastern side has to be cleared by the respondent number 3 and 4. The direction was not to.
Who is appealing for respondent 3 and 4?
3 and 4.
What has happened?
What has happened is they are the tenant.
Hmm?
Initially, their father was the tenant. After from 1987, a fresh agreement was executed in April 2021. The agreement clearly provides that they will have ingress and egress through the eastern side. Lordship may kindly have a look at the agreement in the writ petition matter, page 13. Lordship may just 39.
Page 39.
39. This they never say, they only say that south, eastern and western. 39 Lordship has got clause 8, para 8. That the space between the footpath and the shop premises will remain under the exclusive ownership of the first party, that is the landlord. And the second party cannot use this space in any way or manner as he likes or cause inconvenience to the other tenants of the building. This is the southern side. Lordship, on the eastern side, they have got their entrance for the shop. Southern side, Lordship knows this is in Laktokia. Southern side means after the southern side, there is steps and then the road. Eastern side, they have got their entrance for the shop. They want that this agreement is there, the southern side will be of the landlord. It clearly says exclusive ownership of the first party, there is the landlord. Now, through this writ petition and this proceeding, they want that southern side also should be open for them, which is against the agreement. Against the agreement.
But an order was passed.
But I'm coming to that. Order also, my learned friend also not clarified. First order was passed on 17/12/2024, which your Lordship has seen.
Hmm.
Now, this order was on the next day itself modified at the instance of the present respondent.
Now, where is the modified order?
That is at page.
No, that this is
Huh.
the modified.
Page
This is the modified.
modified order page.
I have not read the unmodified order.
All
I
right.
have not paid-
No. The paragraph above that was not read.
No, which one? Which way the
Page
page?
17 also will come again. They want the removal of the kiosk. The order is this. My first order was passed on 17/12 for removal. That your lordship has seen, my lord.
Now, the second order is in 1812.
18/12. Now, lordship will kindly come to page 17, para 14. My learned friend has read para 17, but para 14 is important.
Okay.
In view of the order passed today, the
Hmm.
order of 17/12, that is the just previous day, my lord, 17/12, more particularly the direction at paragraph 8 of the said order will stand modified to the extent that the GMC authorities will issue notice to the said Mahmudul Alam, if not already issued, and therefore Mahmud Alam is a tenant, my lord. And upon due verification shall decide on the aspect of the grant of trade license to such a person to run the shop at the same premises where the kiosk is permitted to be erected, and also to examine whether there is any violation of the building bylaw, rules and GMC and GMD authorities by the so and the respondent number 3 and 4, while executing the said tenanted lease agreement between them, if any such violation is noticed, appropriate action will be taken by the GMC authorities under the provisions of law. Then paragraph 17, respondent number 3 and 4 will ensure removal of the obstruction on the eastern side. Let me kindly say on the eastern side, and that is removed already. And ensuring entry and exit through the southern side within 3 days from today without affecting the kiosk. Kiosk is there, and the court is saying that without affecting the kiosk.
So that has been done.
My lord, lordship will now kindly come to what is their contention. My lord, may kindly come to this their petition, paragraph 6 at page 5. Because subsequently there is another repetition by the tenant, my lord, of that kiosk. Or not this tenant, he is also tenant. He is also under a tenant, my lord, page 5, para 6 of the contempt petition, my lord.
Of the contempt petition.
Contempt petition.
Page 5, para 6.
My
Yes.
that it is submitted that honorable court gave a specific direction to the respondent contemners to give access to the writ petitioners applicants from the southern side within 3 days of the aforesaid order, it is so and so, 1812, my lord. But the respondent contemners is yet to give access to the writ petitioners applicants of their shop from the southern side till date. The structure which was before the shop of the petitioners was removed on 18/3/2025 night. It was removed by later on GMC has clarified, they have removed, my lord. Immediately thereafter, the contemners erected bamboo structure on 19/3/2025 early morning and started stuffing with goods. Furthermore, the contemners had put up some so-and-so adhesive and inside the locks of the shop shutter, due to which petitioners were unable to open the lock. Faced with the contemners' illegal activities, the petitioners knocked the doors of the GMC as well as the local police. Now, this is the position, my lord. Now, lordship will kindly see the order when the tenant of the kiosk approached this honorable court in the meantime. What was the order passed there in, my lord? That your lordship will find at page 47, my lord.
47 of?
47, my lord, this is a running page. It is actually part of our affidavit of opposition.
Page 47.
47 running page, my lord. In the meantime, the tenant of the kiosk approached in WPC number 1741, which starts from page 46, my lord. And page 47, well, it starts, hard, Mr. So-and-so, learned counsel for the petitioner, and Mr. So-and-so, learned standing counsel GMC for the respondent number 1 and 5. Mr. Nayak, learned standing counsel GMC, has submitted that he will obtain instruction whether petitioner has been issued any notice in terms of the observations made in paragraph 14 of the order dated 18/12/2024, passed in petition number so-and-so. Mr.
So, I mean, how can now this can be executed? Let both the matters can be heard together.
My lordship kindly see, that's the next paragraph, which says, Mr. Pathak, learned counsel for the petitioner, submitted that on 18/3/2024, GMC authorities had carried out a dismantling exercise whereby the Arungate in front of the petitioner shop had been
Dismantled.
dismantled and taken away. Next paragraph, my lord. Having heard to the projection made on behalf of the petitioner, it is observed that till the next date of listing, the party shall maintain status quo existing as on today. And then subsequently, my lord, this case was disposed of page by an order at page 53.
Okay, disposed of.
My lord, maintain with the direction to maintain status 4/4/2025, and the operative part is at page 56, my lord.
Yes.
Last paragraph, my lord. While parting with this court is of the considered view that the issuance of notice to the petitioner should be given a proper and effective opportunity to respond to the said notice, and the proceedings so initiated should be brought to its conclusion in accordance with the law by following the principle of necessities, balancing the equities, and for the answer that is, it is observed that till the disposal of the proceedings to be initiated by the issuance of notice, the party shall maintain status quo as on today. And just above paragraph, it is said it is accordingly closed. This petition is closed. So this status quo order remains at the instance of the tenant in respect of the kiosk. And they themselves are saying that immediately after 18 GMC has removed it. Then they are now saying that there is some bamboo structure. If the tenant of the kiosk has put some bamboo structure, and thereafter this honorable court has passed an order of status quo, where is the content, my lord? And moreover, my lord, what I have shown from the agreement itself is eastern side door is open. You can do your business through the eastern side. Western side from your shop till the road down through the steps. This has to be exclusively in the possession of the landlord. Now you want through these writ proceedings to open an exit through that southern side, which will be going against your own agreement.
But now this is status quo order is still there.
May I explain?
No.
Yes.
If status quo is there, then how can the contempt petition can be executed?
Yeah, that's, may be allowed. Lordship, the earlier interim order get merged with the final order. That's my, on 4/4, when this order was passed, Lordship may come to page 54 for a moment.
54 for?
54 of, Lordship was reading, of the contempt petition, affidavit in opposition. 54.
54 is the order.
Yes, 4/4 order continuing, it starts from 53.
No, I mean,
In the contempt petition, the affidavit filed by my learned senior friend, senior counsel.
54 is the order he was reading just now.
Yes. I just want to show Lordship, 54, para 4, the court says 1812 order. This order is in cognizance of the order of that the honorable learned single. That's
correct.
that's
After
Yes,
that, they have
yes,
he has
yes.
passed it.
Then, Lordship, next para. The petitioner has approached this court by instant writ petition alleging high-handed part on the respondent GMC authorities by stating on 18/3 the respondent authorities has carried out dismantling exercise whereby the iron frame standing in front of the petitioner tenanted premises has been dismantled and taken away without prior notice as observed in para 14 of the interim order of 18/12/24. Now, second, when the writ petition was moved on 26/3/25, this court, after hearing the learned counsel for the parties, has observed in the interim that till the next date of listing, the parties shall maintain status quo existing on that date. Thereafter, on 28/3/25, when the case was listed again, the respondent authorities were asked to ensure appropriate preservation of the iron frame stated to have been dismantled from the petitioner shop, and the parties were asked to maintain status quo existing on that date with regard to the shop of the petitioner.
Yes.
Lordship, in my respectful submission, with regard to the shop of the petitioner, has to be understood with respect to the iron frame.
Okay.
This is my respectful submission. When this line, the iron frame has to be understood with the shop of the petitioner. What the honorable court had probably intended to say is that if there is an iron frame, it is not removed or whatever be, it has to be kept that way. There is no mention of any bamboo structure here. They are trying to read between the lines, but in my respectful submission, I'll also show as the deed of agreement which they themselves executed. Thereafter, Mr. Nayak, learned sending counsel has submitted that since there appears to be various certain violation in operating the garment shop by the petitioner from the tenanted premises rented out to the petitioner by the landlord, the GMC authorities are contemplating to issue notice in terms of observation made in paragraph 14 of the interim order. So they say, which is the tenanted part, which part has been, now lordship, there is a space on, now is there any, the space was shown on 15/10/24, it was an empty space. There is a dispute, civil dispute which started, they did not get the injunction order there, so they build that structure. It is not anything else. Now, that I'll show by their own documents, not my documents. Thereafter, now the status quo that has been mentioned, it mentioned as respect to the fact that there is nothing on record to say that they have stated that they have erected a bamboo structure after the dismantling of the kiosk. If a single document is produced as of date that they have said that they have constructed a bamboo structure and that bamboo structure was in place,
They have stated in their, which I have.
no,
transparency,
they have stated.
They have
The-
stated
stated that
at that-
bamboo structure on 19/3.
Yes.
18/3 it was removed and 19/3 they have stated.
Yes, we have stated.
19/3 a bamboo structure was erected.
My submission is that
Status
when
quo
they
order-
approach the
status quo
court,
order is after that.
when they approach the court, did they state in their writ petition that there was a bamboo structure? Did they inform the court that there was an existing bamboo structure?
But I am appearing for kiosk. While that petition was moved to, specific amendment was made in the petition, but after the iron crane was removed, without issuance of the required notice under the CMC Act, there was a bamboo structure. The photographs here also, which were before the grid code in those specifics. I have also annexed in my affidavit of opposition filed in the bamboo structure is clearly visible.
So bamboo structure was still there.
When the order was passed.
When order was passed, and ultimately when the matter was closed, that also bamboo structure was there, and the status quo order is still there.
The honorable court was aware that there was a bamboo structure, was a part of my written pleadings as well as the photographs were also.
That is not a part of this record.
I have also mentioned it in my.
No, that is not a part of this record. So because we are not.
No, that is a part of this record. Your lordship can see the photographs of page number 147.
147 of the writ petition. There are some photographs.
There are some photographs.
Hmm.
Lordship will kindly see the photograph at page number 151. It shows the photographs, the position of the kiosk after the dismantling exercise and the previous day, 18/3/20. And regarding the pleading, your lordship, I have made a specific pleading in my.
Oh, this is the bamboo structure,
This is the bamboo structure.
where this all these, I mean, garments are there.
Yes.
Lordship, I have already provided, this is there, I'm not dismayed. And these things are already there. I have provided separate photographs which are part of the record.
If I may take your lordship to paragraph number 13 of this affidavit.
Is there any urgency in the matter? And I think like
My-
I'll have to consider a lot many things in this case.
Lordship, that way, I understand, urgency is there, a date may be fixed in that event, because my shop has been closed. I'm not being able to.
Eastern side it is open.
If the part, my shop is on it's from the road.
No, I think, see, I mean, your grievance is basically southern side also you want.
Yes, which is being
But,
given by the
no,
court.
no, but thing is that as for the, I mean,
Agreement.
as per the agreement, that is not there,
No.
first thing. Secondly, eastern side is already clear,
Yes.
already clear. So I don't think like you have any issues. I mean,
No, lordship,
yeah, only issue is that like you can hesitate is that I mean, order that has to be scrutinized now.
Yes, that.
So since, this will require some time, Mr.
Possible date may be, a fixed date may be given. That's only after Bihu vacation immediately, because I have been out
Eastern
of.
side,
business.
eastern side, why are they saying out of business? Eastern side is open. You are already
Because if-
carrying on, you can carry on business through the eastern side.
Lordship.
And as per the agreement, eastern side, you have to carry on the business.
Lordship.
Western side, it will remain in the possession of the landlord.
This is the latest photograph which I have annexed. They are saying eastern side is there. This is the latest photograph. We are not being allowed to, this is there as a marked as part X. They are saying do it from eastern side. From where will I enter? And this is this is in the record. Now they are saying go to eastern side. I'm not being allowed to enter. They are putting everything in.
No.
This is the
Eastern side is open.
This is the record. This is on record. This is on X. This is eastern side. This is eastern side. This is eastern side. This is southern side. This is the way it is. This is on record. And on the
On
last
eastern side, the shutter has been kept down.
no, that is this is
You
we are
have
not allowed-
deliberately, if you keep your shutter down, and then naturally there are some roadside.
I'm not being
vendors.
allowed to enter.
No, your shutter is down.
No, that is the part. Now these
You
are
have
the part
taken
of
a
the record.
photograph where the shutter, yourself, you have brought down the shutter.
Because
You want the opening through the southern side, which is beyond the agreement, my lord.
Watch may fix a date.
Okay, we'll fix it. I mean,
That's
it
not
need,
for any
it will
purpose.
need some consideration.
I'm just saying that they can carry on their business through the eastern
You
side.
can carry on.
Lordship, I am not being
You have-
allowed to enter from the inside. That is a different part.
Your
But
shutter
you have
is
the
down.
southern side.
Southern side is closed. That's where the southern side is closed. That's where the picture is showing. I don't have the eastern as well as southern side.
Okay, we'll consider it after. I
Date
mean,
may
it
be
will need some consideration.
Date may be fixed. That's my only prayer because I'm out of business since 24.
The problem is that in that place, you'll have to do business like that only.
I understand. Date may be fixed. That's my only.
Mr. R. Das, the learned counsel.
RJ, that's possible.
RJ Das, the learned counsel, appearing for the petitioner. Also have Mr. D.K. Mazumdar, the learned counsel, appearing for respondent number. Mr. Mazumdar is appearing for Mr. Alam.
Yes, in respondent number 3 and 4 in the writ petition and the respondents in the condemned petition.
1 and 2. And Mr. Pathak is appearing for?
5 in the writ petition. Included later.
You have implemented in this case?
Yes, later.
Contempt.
No.
Writ petition is still pending, no? Because of the interim.
Yes,
only.
yes.
Okay, so and so, and you are also appearing for, you are assisting Mr. So Mr. Deka. Mr. Deka, your full name? Mr. A. Deka is D. Mazumdar assisted by so and so. Mr. Naik is also appearing in the writ petition for GMC.
James.
Writ petition for GMC. Let both the matters be listed on
27th, madam.
30th, on a hearing date,
Gotcha.
30th April.
No, 30th, there are 4 or 5 matters, madam.
Okay.
Number 1 also there are matters.
Okay, then first week of May sometime.
Yes,
Date may be fixed only.
7th of May.
7th, yes.
7th.
Lordship, I am extremely sorry. 7th,
I
I'll
mean,
be
you have
Janagar.
difficulties.
Maybe on 5th.
5th will be difficult. Lot of matters have been fixed. I mean, so 12th will do it. 12th.
12th May.
12th
Good.
May. 12th May.
Tuesday.
Okay.
Diploma.
Baकी ऐसे बोलना। Yeah, sir.
My lord, from the Lazimus order, it appears that respondent number 5 is not served. My lord, I am deleting his name because he is a contractor. Now.
So you file an application. File an application to strike off his name. That has to be done as part of procedure. You'll have to file an IA.
There is no dispute and now they have filed affidavit.
No, correct, but you have made a party, so if you want to strike off somebody's name, now the procedure is that you have to file in IA has to be allowed, then that will be strike off, then that will be, then you'll have to file an amended cost title. That is the procedure now.
Actually, there is no dispute. They have.
No, correct, now you have
filed
made a
the
party.
affidavit and we also support that. So in that view, my lord, case may be disposed of your lordship, if your lordship so desires. Because in para 5 is my case, madam. There was a 100 years old road. Para 5 of my petition may be seen.
5 is who?
No.
5 is
5
private
is
respondent.
contractor.
Huh?
Contractor.
Why you have made the contractor a party?
Because contractor was acting in a manner which was not the sanctioned road. He trespassed into our land. But now the government has filed affidavit.
Hmm.
In affidavit, my lord, we see.
Then we'll
that-
put it, I mean, is it so? Contractor is not required. You file any affidavit?
They have filed affidavit.
Huh.
Their affidavit we also have.
number 4 also.
Huh.
In our affidavit.
Hmm. Para number 4.
Yes.
But actually, I am submitting what the.
One second. They are saying no new road has been constructed
Yes. that
and
is
no
also-
acquisition process is initiated.
But earlier, my lord, the circle officer along with the contractor.
So,
wanted-
so that means nothing remains in the petition. What remains?
Of course, my lord, if they construct the or repair the old way, we have nothing to say. But they wanted to cross our land. I have given some pictures, kindly see.
So
Some
that,
of
Our affidavit.
okay, I mean, then I think we'll have to put it for admission on another date. You file an application for striking of his name. That's a process, but you can't escape that. no?
After vacation, let it come then.
In the meantime, you file it this thing, then we'll pass it on. Mr. M.U. heard Mr. M.U. Mahmood, the learned counsel for the petitioners, also heard Mr. S.K. Hazarika, learned counsel. Opinion for
2 and 3.
2 and 3. Mohanta for 2 and yes, for number 1. Mr. Naik is also there. Mr. Naik, the additional advocate general for respondent of 4. On the prayer of Mr. M.U. Mahmood, then let the matter be listed after the view vacation. In the meantime, you file in IS.
All right.
28.
So I have for substitution, lordship. Respondent number 6 has been transferred from.
Lordship
Respondent number 6 has been
will take
transferred.
up the IA number 826 or 26. So there is a pair, my lord, to substitute the respondent number 6 with the present incumbent, my lord. This is not a contempt. If petition, Malafide was alleged against the then commissioner. Now he cannot be replaced by the present commissioner. This is not a contempt petition, my
My lordship,
Now, how can, see, malafide can be alleged only against an individual, right? So no, now then you have made a one person a party alleging a malafide against him. Now, how can you, I mean, like somebody else has come, then you can allege against him?
lordship, thing is that then we have to strike him out, lordship.
Whom?
The respondent number 6, because he is not there holding, now he is not holding the office, lordship.
But malafide will be still there, allegations of malafide, he can still be a party.
And state says are not also be taken, my lord, against the respondent number 6.
We have taken the step, lordship. That
There is
is
a law
avoided
order
because his
also.
address has been changed, lordship.
There is a law dated 9/3/2026, my lord. Steps have not been taken against respondent number 6.
The
The
address
main
has been
petition.
changed, lordship.
Main petition. Was. You have not appeared before the law court.
That to multiple times. my lord.
Yes, 7-3 also.
Yes, lordship.
So we'll dismiss your petition if it happens like this.
Lordship, thing is that We have taken the step earlier, Lordship.
You have taken the step, was not, notice was not served, that's why Lodgema matter was placed before the Lodgema court. A cause list comes, which are the matters before the Lodgema court, and you don't appear for last 3-4 occasions you have not appeared. The petition is liable to be dismissed, in fact. Okay, you take steps.
Lordship.
Then you decide on this, what is to be done on this. If it is true that like if you are alleging malafide against one person, you cannot replace him with another officer.
Lordship, we will take first step. First step, Lordship, we will take, Lordship.
Respondent number 6 is who? That person?
Then Commissioner, my lord,
Commissioner.
GMC.
Okay, you heard Mr. So-and-so, learned counsel appearing for the petitioner. Also heard Mr. S. Bora, the learned counsel appearing for
GMC, my lord.
GMP, and S.K. Hazarika for respondent number
1, 2, and 5.
the Lodgema court order dated 9/3/2026 reveals that no steps has been taken for service of notice on respondent number 6. Full stop. The counsel appearing for the petitioner submits that he will take fresh steps for service of notice on respondent number 6. Is allowed, it is directed that the petitioner, the counsel for the petitioner will take steps on respondent number 6 within a period of 2 days from today. By tomorrow you take it, otherwise it will be off.
Tomorrow.
But 6 is already gone, right?
It's
Yes,
already gone.
Hmm.
If you want to delete, he said one that he want to delete.
So I mean, there is no
another
point, there
process.
is no point taking steps also now.
Lordship.
Then you write, however, the learned counsel, don't write, take steps, huh? No notice has been served on so and so हो गया. इसके बाद लिखो, the learned counsel for appearing for the petitioner submits that he has filed an IA
I have got substitute for.
you take proper instructions what is to be done, because malafide is there. I mean, malafide is there, then I mean, how can it be substituted by a different officer?
And he was not present at that particular point of time.
We'll place it, we'll list it after the vacation. By that time you decide what is to be done.
Lordship.
You see, like, I mean, you see the provisions of law also. If there is a allegation of malafide, whether he can be substituted by a different officer. You can't do that. So this has to be rejected then. You write, cut the whole thing, you write so and so, and present their name, list the matter after the BU vacation. List the matter in the first week of May. We decide what is to be done.
Lordship.
Then we'll-
29.
Please,
Series of cases, my lord. Earlier, I was the counsel for the Assam State Textile Corporation, my lord, but now, my lord, when this textile.
I think I cannot take up this matter. I was handling some.
Lordship
things.
handle
Mm.
this matter.
My prayer now today is before Lordship to strike out my name from these cases, my lord. I am no longer there. Perhaps your Lordship can do, my lord.
You are no longer there.
No, I am no longer.
Let it come before a different bench, because I have already I have advised in this matter, handle this matter. You bear it for one day. I mean, doesn't look good actually.
No, that's all.
Let the matter be placed before an appropriate bench without me.
Right.
You can send somebody else also, your junior somebody,
Yes,
then
yes.
your name can be struck.
After,
Let
let it come after due vacation.
No, we after due vacation.
Lordship.
There is no time now.
Please.
The bank officials has come.
Is a payment.
But then you file affidavit, whatever you want to do.
filed a
Mr. A. Kanikot, a learned counsel appearing for the petitioner, also heard Mr.
R. Chakraborty.
R Chakraborty,
R Chakraborty, the learned counsel, appearing for
2 and 3.
respondent number 2 and 3, and you? S Kakoti for respondent number 1. Respondent number 1, CCC. Okay,
This is a formal part.
huh?
This is not formal part.
Okay. Then let the matter be placed, let the matter be listed for the admission in usual course. After the,
Immediately after, this is urgency.
after the BU exam, let them file affidavit. They'll take some time in view.